Good morning, Your Honor. Paula Michelle Lofton on behalf of. Good morning, Your Honor. On behalf of the Crumbley. Good morning, Your Honor. Deliberation myself on behalf.
Thank you, and good morning to everyone who may all be seated. Today's a time set for our continuation of the Miller hearing in this case. When we were last here, the defense had arrested and the people intended on calling a rebuttal witness. With that, anything we need to discuss before we continue with the Miller hearing?
No doubt.
Thank you, people. You may call your rebuttal witness.
Thank you. People call Dr. Lisa Anaher.
Doctor, you're going to approach the witness stand. You're going to stand in the witness box. Face my clerk to be sworn, please.
Please raise your hand. Under penalty of perjury, do you swear or affirm the statements you're about to make to the court will be the whole truth? I do. Thank you, ma'am.
If you remember, if you could, please state your full name for the record and spell your last name.
Yes, my name is Lisa Anaher. My last name is spelled A-N-A-C-A-E-R.
Thank you. People, your witness.
Thank you, Judge. Good morning. How are you employed?
I'm a staff psychiatrist and consultant forensic examiner employed at the Center for Forensic Psychiatry.
Thank you, Doctor. And could you please briefly describe your educational and professional background?
Yes. I completed 4 years of college, 4 years of medical school, followed by 4 years of psychiatry residency training through the University of Michigan's Department of Psychiatry. Following that, I completed an additional year of subspecialty training in the field of forensic psychiatry.
You're a medical doctor, is that correct?
Yes, I'm a medical doctor.
Thank you. Now, could you please describe some of your postdoctoral training as well?
Yes. After medical school, as I mentioned, I completed 4 years of training in psychiatry residency at the University of Michigan. Psychiatry residency consists of a variety of clinical rotations to gain additional expertise in a variety of areas. These can include things like neurology, inpatient and outpatient psychiatry, addiction medicine, child psychiatry, geriatric psychiatry, psychotherapy, among many others.
Thank you, Doctor. Are you a member of any professional organization?
I am. Among others, I'm a member of the American Academy of Psychiatry and the Law, which is the professional organization related to forensic psychiatry.
Are you board certified in forensic psychiatry?
I am.
Can you please tell us what that means and why it's important?
Forensic psychiatry is the subspecialty of psychiatry that's particularly at the intersection of medicine and the law. So forensic psychiatrists are medical doctors, particularly psychiatrists, who've undergone an additional year of training to gain further clinical expertise in areas like civil and criminal competencies, criminal responsibility evaluations, violence risk assessments, and others.
And do you teach as well?
I do. In addition to my role at the Center for Forensic Psychiatry, I'm also an adjunct faculty member at the University of Michigan's Department of Psychiatry. And in that role, I teach medical students, residents, and fellows in topics related to forensic psychiatry.
Now, as a medical doctor, do you have a license to prescribe medication to the Drug Enforcement Administration?
I do.
What does that mean?
It means as a medical doctor with that license, I can prescribe medications to patients in clinical settings.
Now, tell us, please, Doctor, if you could, what does a staff psychiatrist and consultant forensic examiner at the Forensic Center do?
As a staff psychiatrist, I've treated patients at the center, which is a state hospital in Michigan. Patients who are admitted to the center are typically those who have been found not guilty by reason of insanity or incompetent to stand trial. Many of the patients at the center have serious mental illness, so treatment can involve medications and therapy. As a consulting forensic examiner, I conduct court-ordered forensic evaluations, most likely in competency to stand trial and criminal responsibility.
Okay, and how many of those forensic examinations have you conducted to date?
I've conducted 525 evaluations in the last 5 years.
Thank you, Doctor. Could you please tell us the process when you undergo when you complete a forensic examination outside of that?
Yes, when we complete forensic evaluation, typically starts with the review of the data that's sent to us, which typically involves a court order, which is simply the document that outlines what evaluation the judge wants us to do, and also the review of the police report that accompanies the charges. I then typically consult with the defense attorneys to hear their concerns and reasons for the referral, and then I interview the defendant. Following that, I decide whether or not further data is needed. That further data can include things like psych testing by the specific question, or it can involve things like asking for body camera videos, asking for records from hospitals or other medical providers, or asking for records from jails or prisons where the defendant has been located.
So if I'm following you, it's your objective to gather as much information as possible when you're going this exercise.
Absolutely. The more data, the better in terms of evaluation.
Doctor, have you also studied studied mental illness and the effects of mental illness more broadly?
I have.
Specifically, have you studied the intersection of mental illness and violence?
Yes, I've co-authored papers on mental illness and gun violence among other papers.
You've been qualified as an expert in the field of forensic psychiatry in the past.
I have. I've been qualified approximately 50 times in various counties, including Michigan.
May I approach you?
Yes.
People over 66. Doctor, can you please tell me what I just interviewed?
This is a copy of my CD.
Is that your most up-to-date CV?
Yes,
Judge, at this point, the people will move to amend 66 as well as who to qualify this witness as an expert in the field of forensic psychiatry.
Any objection to items?
Okay.
Thank you. With that, people 66 is admitted into evidence. This witness will be reflected as a witness as an expert in the area of forensic psychiatry.
Thank you, Judge.
You're very welcome. May continue.
Doctor, you always author a report after conducting a forensic examination.
I do.
And when you write that report, you document the materials you review and coming to your conclusion.
I do.
Would that be the best practice in the field?
I would say so, yes.
Why is that?
It's important when the readers of our report, which are typically attorneys and judges, that they know where our opinion came from and what we relied upon to come to our opinion. It's also important when we're testifying to know and use the reference when we're speaking about our opinion.
Doctor, are you familiar with the defendant in this case?
I am.
Did you evaluate him in your capacity as a consulting forensic examiner for the forensic center?
I did.
And when was that?
I evaluated him on March 15th, 2022.
What was the purpose for that?
I saw him at that time for an evaluation relative to his criminal responsibility.
Did you prepare a report?
I did.
May I approach the answer?
Yes.
Been admitted as people 64. Doctor, do you recognize that?
I do.
And what is that?
This is my report regarding his criminal responsibility dated March 29, 2022.
Okay, you authored that report?
I did.
This is Defense Exhibit N as in Nancy. This is a report authored by Dr. Colin Kane in June of 2023. You've seen that before.
I have, yes.
Doctor, I would like you just to have all three of those exhibits next to you, and if you need to refer to them for any reason, just please let the court know. Now, the purpose for the evaluation that you conducted and Dr. Colin King conducted were different. Is that correct?
That's correct.
But they did in fact address many of the same issues. Would that be right?
That's correct.
Now, in your report, it appears that the sources of information that you relied upon span the first 6 pages of Exhibit 64. Is that right?
That's right.
Now, Doctor, were you able to listen to Dr. King's testimony on August the 1st of this year?
It was.
So, correct me if I'm wrong, but according to your report, Dr. King's testimony, it appears that you reviewed all of the information that Dr. King reviewed, aside from some self-reporting that the defendant made to Dr. King. Is that right?
That's my understanding, yes.
Now, I want to address a few points in Dr. King's testimony in his report and ask you to agree or disagree. So, first, Dr. King testified that the defendant is without question someone who is mentally ill. Do you recall that testimony?
I do.
And that was in fact in his report.
That's true.
And in Dr. King's report, he was referencing the Michigan statute defining mental illness. Is that right?
That's right.
Do you agree that this defendant needs a statutory definition for someone who is mentally ill?
I don't.
Could you please explain that?
Yes. I want to start by saying that the common conception of mental illness, for example, if someone has anxiety or depression, that's different than mental illness that is defined by Michigan statute. My understanding of Michigan's definition of mental illness is that it is a substantial disorder of thought or mood that significantly impairs someone's judgment, behavior, capacity to recognize reality, or ability to cope with the ordinary demands of life. So in my earlier example, someone who has anxiety or depression and that's see a therapist might not meet criteria for a statutorily defined mental illness because it doesn't rise to that threshold of a substantial disorder of thought or mood. Now, the statute doesn't specify which disorder automatically meets criteria, but the notion of a substantial disorder of thought or mood is thought to apply most readily to something like psychosis, which is a gross impairment in recognizing realities, or to something like a major mood episode, like a manic episode or a profound mood episode. So in this particular case, I took all of the data that I have available to me, including the defendant's report to me during our multi-hour interview, as well as all the information that I listed, to come to a conclusion that he did not meet criteria for a substantial disorder of thought or mood, specifically at the time of the shooting.
Well, doctor, somebody could actually be experiencing internal crisis or symptoms of depression and still not meet the definition of mental illness, certainly not psychotic, is that right?
Correct.
Doctor, you report when the defense played the videos of the defendant in the Oakland County Jail. That was defense exhibit S and Susan. First of all, did you know that incident, those videos were depicted from one incident in particular?
I was told that, yes.
Okay, and that was from May the 26th of 2023, which would have been about a year and a half after the defendant had been locked in the Oakland County Jail after the murder. Is that right?
Correct.
Okay. Dr. King testified that those videos were evidence that the defendant was in throes of psychosis. What do you make of those videos?
So those videos were taken from an incident in May of 2023 of this year. So those videos tell us about the defendant's mental state during that one incident in May of this year. It tells us nothing about what the defendant's mental state was like in November of 2021 when the shooting occurred. Now, whether the defendant has developed depression or an adjustment disorder like the jail psychiatrist testified in the year and a half that he's been in jail in a cell by himself, it's possible. But I do think it's important to note that the jail psychiatrist who has been seeing the defendant during her testimony still noted that the defendant was not psychotic and did not treat him for a psychotic disorder even after those videos occurred in May of 2023.
Doctor, you're referring to Dr. Gadar, who testified in, I think, July the 28th of this year, is that correct?
Correct.
And of course, you were in court for that testimony?
Correct.
And you reviewed her records as well?
I did.
Now, specifically, Dr. King testified that he diagnosed the defendant with major depressive disorder, severe with psychotic features. Do you agree with that diagnosis?
I don't.
Tell us why.
There are several reasons. I want to start by saying that when we try to diagnose someone in a forensic assessment, or when we're trying to decide whether someone meets criteria for that statutory definition of mental illness, we like to rely on multiple sources of data. Now, there's subjective data, and then there's also objective data. And an example of a subjective piece of data would be the defendant's self-report. It is an important piece of data that we consider, but it is subjective. It's their own experience of what they were going through. Now, an example that might help people understand is if you go to your doctor and you walk in and you say, I have pneumonia, you would expect that that doctor would do more than just take your word for it. You would expect that they would use their clinical judgment and their expertise to determine whether what you're saying actually meets the clinical diagnosis that you think you have. And it's the same way with mental illness. So if someone says they have hallucinations, we need to do more than just take that at face value. We need to use our expertise as well as all the other data that we have in a case to determine whether that's true.
So, doctor, if I could interject, that doesn't mean that he didn't tell his friend, that he didn't tell his parents. It just means as a clinician, we want to do further investigation before you get an actual diagnosis.
Correct.
Okay.
Correct. And so my understanding of Dr. King's diagnoses is that he relied on the defendant's self-report and what he self-reported in text messages, for example, as well as on a variety of psychological tests that we conducted, the majority of which were self-report checklists to come to that conclusion. Now, when I decided whether or not he had a statutorily defined mental illness, I took into account what the defendant told me and those text messages that were referenced, but I also looked at the more objective data that we have in this case, and there's actually quite a lot. So for example, objective data would be something like the videos of the defendant immediately after the shooting, during the shooting, in the police substation. And in those videos, there's no evidence that the defendant was objectively exhibiting signs of psychosis during that time. So what we see in those videos is that the defendant was communicating clearly, he was calm and collected, he was answering questions relevantly, suggesting reality-oriented thought processing. What we don't see is any signs of bizarre behavior, disorganized speech, responding to internal stimuli.
Can I ask you just right there, what is internal stimuli?
When someone's actively hallucinating, the clinical term that we sometimes use is responding to internal stimuli. So imagine that you're hearing a voice or seeing something that other people can't see or hear. That would be distracting. You might be looking around, trying to figure out where the voice is coming from. You might be talking under your breath, responding to this voice. You might be looking around, seeing something that other people can't. In none of these videos does the defendant appear to be doing that. Now, that would be incredibly atypical to present with none of those signs that I mentioned if someone was in the midst of an acute psychotic episode. In addition to the videos, though, there's also other more objective data that I also considered, and that included all of the jail records where the defendant was monitored quite consistently in the hours, days, weeks, months after this event. And in none of those records does any clinician ever describe him as appearing psychotic, despite some occasional self-reports of hallucinations appearing the same. And so again, that would be quite atypical for someone who was acutely psychotic to then show no signs of psychosis immediately after the shooting and no signs of psychosis in the days, weeks, and months after the shooting, despite not being treated with an antipsychotic medication.
Yeah, nice stuff, you can. Now, Dr. King testified that psychosis can wax. I believe that was during waxing. Now, tell us about that.
While it is true that symptoms of mental illness can appear more severe at some times and be in remission at other times, it would be incredibly atypical for someone who was acutely psychotic to then show no signs of psychosis both during the shooting, immediately after the shooting, and then for months after in jail without treatment. Again, if someone was treated with an antipsychotic, maybe they don't show symptoms. But the defendant has never been treated with an antipsychotic medication, and he's never been diagnosed with psychosis, because no jail clinician ever observed him objectively psychotic.
In fact, Doctor, did you actually ask him about his hearing voices to help in the determination if he was in an acute state of psychosis during the shooting?
I did. So in addition to all that objective data, I asked the defendant if he was hallucinating at the time of the shooting, and he told me he was not. He told me he wasn't hallucinating during the shooting. He told me he wasn't hallucinating in the days prior to the shooting. And I specifically asked him if he was experiencing what's called command hallucinations, which are voices commanding you to do something like harm someone else. And he specifically denied those as well. He also didn't attribute any of his behavior to delusions, and he didn't attribute any of his behavior to psychosis, even subjectively.
So, Doctor, that covers the psychosis aspect of the diagnosis. What about the major depressive diagnosis? Tell us about that.
Yes. So while it's clear that the defendant had signs of low mood and anxiety and loneliness, going back to even spring of 2021, that's apparently text messages. To be diagnosed with a major depressive disorder, it requires a degree of functional impairment that I don't believe the evidence suggests that he had. So for example, even when you look from the spring of 2021 onward, when you look at what the defendant was actually doing in those months after he started reporting low mood, he was working several days a week. He was hanging out with his friend on a regular basis. He was doing things that brought him pleasure, like hobbies of coin collecting and model rocketry. Even as it gets closer to the shooting, it would not be unexpected that when a person would suddenly lose contact with a cherished friend, that person would be more upset and more sad. That, of course, would be an expected reaction. But even in that month, after he loses contact with his friend, he's still doing things that brought him pleasure. He told me that he brought a bird head into school approximately 10 days before the shooting, because that brought him a feeling of pleasure and power. He told me he went to the shooting range with his mom, which he described as fun. When you look at the totality of the data, well, I don't contest that he had low mood. I don't think it met the level of functional impairment that's necessary for a major depressive disorder diagnosis.
Again, doctor, we're not talking about someone who is quote unquote depressed or experiencing crisis. We're talking about the statutory definition to major depressive disorder and psychotic, correct?
Correct. And again, there are different things. It can be difficult to understand. Someone can have anxiety and depression and not meet criteria for a statutorily defined mental illness.
In fact, doctor, in your report, Exhibit 64, you spent considerable time explaining your analysis. I think pages 59 to 64, is that right?
That's right.
Do you have a copy of that?
It should be in that binder. If not, I haven't found it. We're good. I have one right here.
Thank you. My binder goes up to 61, but there's nothing behind.
Say I wrote.
Yes. Thank you. You may continue.
Thank you, Judge. Doctor, in support of his conclusion, Dr. King described some of the defendant's writings as signs of his mental illness and psychosis. He specifically referred to the math assignment from November the 30th, 2021, the morning of the shooting. Can you please tell us your opinion on the writings referred to by Dr. King?
Yes. So instead of an example of a major mood disorder or a cry for help, in my opinion, those writings on the school assignments are best an example of what we call leakage. And leakage in the threat assessment literature is warning behavior that occurs when an individual reveals clues as to their thoughts, their feelings, their fantasies, or their objectives in a way that signals an impending violent act. Now, leakage can be unintentional, but it can also be quite intentional. And the motivations for leakage can include anxiety about the upcoming act, or it can include a desire for notoriety or fame for after the act. And in this particular case, I think that there is data to suggest that the defendant wanted that notoriety. He wanted to be remembered for the shooting, and he wanted to be memorialized for his actions. So in my opinion, those writings on the paper were, again, less an example of a cry for help or a major mood disorder and more an indicative sign of leakage.
Now, doctor, is it significant to you that on November the 30th, 2021, at 9:14 a.m., he was taken from his classroom to a counselor's office and he sat there until 10:52 a.m. when he could have disclosed his plan?
Correct. He had multiple opportunities to receive help and chose not to.
Doctor, is it problematic to form an opinion or diagnosis primarily on a self-report?
It can be, especially when there's other data available, because people can say things for all sorts of reasons. They can be truthful, of course. They could be exaggerating or lying for some sort of secondary meaning, or they could simply be misusing a clinical term. So, for example, we may have all heard people say things like, I was really psychotic yesterday, or I was so manic this morning, or she's schizophrenic. Those are clinical terms that are being misused so that someone can describe their experience, but no clinician would hear that and automatically say, yes, that means you're psychotic. So again, we have to take more than a person's self-report, especially in a case where there's such ample collateral data that is more objective.
But doctor, in Dr. King's report, he indicated that he referred to one day of text messages, that's from April the 5th, 2021, between the defendant and the defendant's friend. You reviewed the entire text thread, would that be right?
I did.
And of course, some of those text messages were quite concerning to you.
Absolutely.
So when you're conducting a forensic examination and you uncover evidence such as this that does cause concern, what do you do with it?
I follow up with the defendant and ask specifically what their thoughts and intentions were when they wrote those things.
Okay. And do you attempt to, like in the case of text messages, for example, find the appropriate context for them?
Yes, the context is always very important.
What did you do in this case regarding text messages?
So the text messages that you're referencing in the spring of 2021, I believe are the ones where he talks to his friend about hallucinations. And I think it's very important to put those in context. So many of those text messages, when you look just beyond the word hallucination, they're being sent late at night when the defendant is alone in his home and when he's watching horror movies. Now, the defendant told me that he believed that his house was haunted ever since he moved in when he was in the 4th grade. And belief in the supernatural is relatively culturally normative in our society and doesn't mean that someone is psychotic. And it wouldn't be unexpected that someone who believed in the supernatural would have that fear heightened when they're alone in a home late at night and they're hearing noises and they're watching a horror movie. So to me, that doesn't mean that someone is psychotic. It means that they, again, are alone in a home watching horror movies and having that fear heightened. There's other context in Dr. King's report. He lists the text messages where the defendant tells his friend about hallucinating in a Spanish class. And if you keep reading, the defendant tells his friend, a girl in my Spanish class saw the hallucination as well. That's not how hallucinations work. We don't share hallucinations. Two people usually don't see the same hallucination. When you put it in context, you would see it's not clinically lining up with what a true hallucination is. He and his friend also go on to say that they both hallucinate at work. So again, while I don't doubt the defendant was trying to express things that he was experiencing, that word hallucinations and including that he was psychotic based on that, it doesn't fit the context and it doesn't fit the clinical diagnosis of psychosis.
Thank you, Doctor. Now, Dr. King also testified that thoughts of suicide are a symptom of psychosis. Do you agree with that statement?
I don't.
And tell me why, please.
It's just not medically correct. Suicidal ideation may seem illogical to many people, but it is different than psychosis. And equating the two and saying that they're the same is not correct.
Now, I want to go back to something you said earlier about objective evidence and how you rely upon it forming a conclusion. So you reviewed all of the evidence in this case, would that be right?
Correct.
Okay, so that includes surveillance video of the shooting from November the 30th, as well as the in-car video when the defendant was arrested.
Correct.
And the video of the defendant being inside the Oakland County Jail after he was arrested.
Correct.
Okay, those are in evidence and you've seen them.
Yes.
Okay, now, so we're clear, this is the sort of objective evidence that you were referring to.
Correct. Those would be examples of more objective evidence.
Okay, now specific to the in-car video, the shooting video, and the interview room video, tell us what was significant to you when you watched that.
When we're watching a video and trying to determine a defendant's mental state at the time that the video occurred, we're looking for things that are there and things that aren't there. So what's there in the videos is the defendant calm, collected, communicating clearly with police and with his parents. He is answering questions relevantly. He is following commands. What isn't there are any signs of psychosis, any signs of bizarre behavior, any speech disorganization, and again, no responding to internal stimuli. And like I mentioned before, this would be quite atypical for someone who was acutely psychotic to have then turned it off and have no signs or symptoms of it, either in those videos or again, subsequently in jail.
And Doctor, specifically the shooting video of November the 30th, you observed the defendant to aim his firearm at individuals, to pick his targets, choose who to shoot and not to shoot. Would that be right?
Yeah.
Now, Dr. King also relied upon the video the defendant filmed of himself the night before the shooting when determining that the defendant was psychotic. We're now pining that he was psychotic. Were you able to put that video in appropriate context as well?
Yes. So the video that was referenced was audio of the defendant speaking the night before the shooting. And I believe what was specifically talked about was concerns that he talked about a demon or about demons. Now, I asked the defendant about that very specifically, and he told me that in no way was he trying to say that he was a demon or referencing a demon. It was a reference to the person he described as his idol, which was the Parkland school shooter. And the Parkland school shooter, he told me, referenced demons during his arrest. So when you put that comment in context, there's no signs that that was psychotic. That was a logical reference to the person that he said was his idol.
Even in effect, parroting the idol.
It was a call out to his idol, yes.
And Judge, for the record, those are exhibits 56 and 57 that we referred to.
Thank you.
Okay, Dr. King spent some time on his method of diagnosis. He testified there are 4 ways to study the brain, diagnose and treat mental illness. Did you hear that?
I did.
Okay. So he first said that this quote was mental health people should look directly at the brain through various brain imaging techniques.
Yes.
He then said the second way is to test the brain directly through psychological instruments.
That's what he said, yes.
He testified that the third way is to use symptom clusters.
Yes.
And the fourth way is to guess. Do you recall that?
I recall that, yes.
Okay. So first, doctor, I'd like to ask you, as an expert in forensic psychiatry, qualified 50 times over, do you utilize brain imaging techniques to come to a diagnosis?
Not typically, no.
Tell me why.
There is no brain scan that can definitively diagnose mental illness. If there was, we would use it on everyone who has symptoms, but the research just isn't there yet. In addition, the times that we do use brain imaging would be for a very specific concern that maybe that there was a medical problem underlying the symptoms. For example, someone's very elderly and they're exhibiting symptoms of psychosis for the first time. We might be concerned that they have a brain tumor or something that might mimic psychiatric illness in that age. So those are the situations where we're most likely going to get brain imaging, and otherwise it's just not typically used to diagnose mental illness.
What about psychological testing?
Psychological testing definitely has important uses, but they're typically to answer a particular question. For example, if I had concern that someone is lingering or feigning symptoms, I might want to do psychological testing. The important thing about psychological testing, though, is that it's a relatively here and now evaluation. So it's going to tell me the defendant's mental state at the time the test is given. And for criminal responsibility, which is what I was evaluating the defendant for, that's an evaluation of the defendant's mental state at the time of the shooting. So a test 6 months later, a year and a half later, is going to be less useful to me than all of the objective data depicting the defendant at the time of the shooting.
Now, you mentioned it. Can you elaborate on the specific tests that the defendant, that Dr. King utilized to evaluate the defendant?
Yes, Dr. King spoke about a variety of tests that he gave the defendant, and with some exception, of course, the majority of those tests were self-report checklists or questionnaires, meaning the defendant, checked boxes or endorsed various symptoms for how he was feeling at the time that the test was given. Now, those can be useful, but it's important to know that most of those tests don't have validity indicators. And what that means is that without validity indicators, we don't know if the defendant was over-reporting symptoms, under-reporting symptoms, or even responding relevantly to the test. So for example, I could give you a self-report questionnaire and you could check every single box and you could say, wow, the results are that you have the worst case of, whatever it is, but we wouldn't know without validity indicators if that was a legitimate response. In addition, 2 of the tests that were given were not normed on juveniles less than the age of 18, so the results may not be valid. One of the tests even had very specifically a checklist for children, and the adult version was used. So again, whether those results are valid is in question. But regardless, I think the takeaway is that with some exceptions, the majority were again self-report questionnaires.
Before you move on, you mentioned 2 of the tests. Do you know specifically which 2 tests?
Yes. So the brief psychiatric rating scale is the one that has a child or a juvenile version. And then the evaluation of competency to stand trial revised is typically normed on adults over the age of 18.
Now, doctor, what do you do when you're the background that?
So to make a psychiatric diagnosis in a forensic assessment or elsewhere, we rely on our diagnostic manual and our clinical judgment and the data that we have in every case. So again, the more pieces of data, the better. But it's not typically done through brain imaging, and while psychological testing can be useful, For criminal responsibility evaluations, we're really looking at what the defendant's telling us. Does it match with the records? Does it match with any video or audio that we have? And then using our clinical judgment to see if it matches with our diagnostic know-how.
Do you guess?
No, I do not guess, and nor does any forensic evaluator that I know guess when doing forensic evaluations.
Doctor, we'll move on to some other testimony from Dr. King. He indicated, and he stated that he had concerns that the defendant suffered a brain injury. Did you hear that testimony?
I did, yes.
Now, I'm not going to ask you to crack an egg, but can you please tell us what a traumatic brain injury was?
Yes. A traumatic brain injury, or TBI, as it's often abbreviated, is a injury to the brain that occurs when there's a blow to the head of some kind. And there usually are recognizable signs or symptoms that occur in the hours, days, months after such an injury.
Okay. So is it fair to say that you don't suffer a brain injury every time you hit your head?
No, not every head injury is a TBI. People can obviously hit their head and not have signs or symptoms of a TBI.
So what are those signs?
So signs of a TBI that you might want to look for in the early hours, especially, would be things like headache, nausea, vomiting, vision, hearing changes, dizziness, balance problems, confusion, memory problems. There are many.
So you reviewed that same video clip that the defense played of the defendant in 2020 at a restaurant, correct?
Correct.
Okay. So first of all, how would you actually diagnose somebody with brain or traumatic brain injury?
So if you're diagnosing someone with a TBI, it can involve brain imaging, but also the majority of the way we diagnose it is with clinical symptoms, because many TBIs, or some of them at least, might not have any brain imaging changes. For example, a concussion is a mild TBI, and there are MRIs of people who have a concussion that would show nothing abnormal. So that's why we rely on clinical symptoms primarily when diagnosing TBIs.
Okay, so you didn't order or request any brain imaging tests?
No.
And why not?
Because I didn't see any evidence of a TBI.
Okay. In fact, you asked the defendant specifically about that diner incident in 2020, is that right?
I did.
What did he say?
He told me that he had forgotten to eat one day and felt lightheaded, and had gone to work, and instead of being able to sit down or lie down or eat something, he continued to work. It was a hot kitchen, there was steam, he was carrying a lot of heavy things, and he felt lightheaded and he fell.
Now, I do want to clear up one other aspect of Dr. King's testimony. He testified that if a child were to get hurt and the parents not take the child to seek medical care, it would be physical abuse. Is that correct?
The term of not getting medical care for a child who needs it would be medical neglect.
Medical neglect. Thank you. Now, Dr. King also testified that he viewed the video of the defendant torturing and killing the baby bird. You recall that testimony?
I do.
And you saw those videos as well?
I did.
Okay. And you also reviewed text messages from the defendant to his friend regarding that same bird incident. Is that correct?
Correct.
So Dr. King's assessment that the defendant wanted them to feel the pain he was feeling. And he said it was a reflection of the defendant's mental impairment. And he also referenced tension reduction. Do you recall that testimony?
I do.
Okay. Do you agree or disagree with Dr. King's assessment there?
I disagree. I asked the defendant very specifically about why he tortured the birds, and at no time did he tell me that it was to feel the birds, feel the pain that he was feeling, or at no time did he tell me it was because of any sort of delusions or hallucinations. He told me very specifically that torturing the birds made him feel good, it made him feel pleasure, it made him feel power. And none of that sounds psychotic.
His report to you regarding the torture of the birds, that's also reflected in the text messages with the defendant sent to his friend. It seems pleasure and power, is that right?
Correct.
When I ask you about a feral child, have you heard the defendant, Dr. King's testimony that the defendant was essentially a feral child, correct?
Correct.
Okay. Now, if you could, Doctor, please tell us what actually is a feral child.
There's not a lot of scientific literature on the topic. I think perhaps it was being used in more of a colloquial sense, but in the scant literature that there is about it, a feral child is typically described as someone who's been raised in the wild and away from human contact, For example, a child who can't speak, because they don't know the English language or any language in the wild. There's also other literature that refers to feral children as people who have trouble with authority and have multiple delinquent behavior on a regular basis as an adolescent or child.
Okay, so with the defendants, with the record that you reviewed, the evidence in this case, the defendant texted in front of them 20,000 times during a period of a year. Is the definition of feral child?
Not according to the scientific literature that I'm using.
And Dr. King also testified that the defendant's form of mental illness, if not treated, typically ends with deadly consequences. Do you agree with that statement?
I don't.
Tell me why.
So, as already stated, I don't believe the defendant met statutory criteria for mental illness at the time of the offenses. But even assuming that what was meant was something like psychosis, it's just absolutely untrue that most people with serious mental illness commit violent acts. In fact, the research shows that the vast majority of violence in our country is caused by people without mental illness. Now, Dr. King then referenced suicide, and it is true that people with mental illness are more likely to harm themselves than other people. But I don't see how that particularly applies in this case, given that the defendant specifically did not want to commit suicide so that he could see the results of his actions. So I don't agree with that statement, and I don't think it's supported by the data.
Dr. King also diagnosed the defendant with obsessive compulsive disorder and indicated that it was the defendant's excessive thoughts and compulsion that propelled him to take the lives of innocent people. That was his testimony. You agree with that?
I don't.
Tell me why.
Obsessive compulsive disorder is a diagnosis that's typically characterized by intrusive and unwanted thoughts that cause marked impairment or distress in an individual. I think in this case, there is significant evidence to suggest that the recurrent violent thoughts that the defendant had from a young age were not intrusive and unwanted, but rather enjoyed and liked. He said this to me not only in his own self-report, but it's also throughout the text messages. It's also in the jail records when they asked him about these violent thoughts. So I don't believe that any sort of clinical obsessions or compulsions propelled his behavior. I also think, again, it's important to look at the jail records where he's been seen very regularly in the days, weeks, months, and years after these offenses. There's no clinician that's diagnosed him with obsessive compulsive disorder there. He hasn't shown signs of obsessive compulsive disorder as we know it clinically. And so, no, I do not believe that that drove his actions on that.
And Doctor, you can understand, can't you, why it's hard to believe that when someone enjoys torture, methodically plans a mass murder, how that person can actually not be the same. You can understand how that's hard to understand, right?
Absolutely.
And tell me about that.
I can absolutely understand how it would be difficult to imagine how a sane person could commit mass murder. But the research does show us that mental illness does not account for most of the violence in our country. And while it's certainly true that there may have been episodes of mass murder where the person had some broad-based mental health concerns, the research just shows us that it's rare. So it's hard to imagine, but it is rare.
Again, Doctor, I brought this up to you before, but it bears repeating. Someone can display signs of crisis and being in quote-unquote depression without actually meeting that definition. Is that right?
Correct. Someone can have depression, they can have anxiety, and not meet criteria for the statutory definition of mental illness.
Is that your opinion would happen in this case?
That is my opinion in this case. In fact, it was my opinion that he was criminally responsible and that he understood the nature of what he was doing at the time of the shooting and the consequences of it.
Thank you, Doctor. One moment.
Absolutely.
Doctor, you mentioned brain injury and your analysis of the defendant. Did you screen for any other issues? Something that's been brought to fetal alcohol syndrome. Screen for that.
We screen for everything when we're doing this, or maybe screen is the wrong word. We consider every diagnosis when we're seeing a defendant for a forensic evaluation.
Tell me your opinion on specifically fetal alcohol syndrome.
Fetal alcohol syndrome is typically characterized by someone who had exposure to alcohol and food, and is characterized by things like what we call dysmorphic facial features, meaning there's a typical facial presentation of people typically with fetal alcohol syndrome. But it's also characterized typically by things like intellectual disability, cognitive impairments, attention problems, impulsivity, things of that nature. And so, again, I don't write every diagnosis that I don't think he has in my report. But in this particular case, if you're asking about fetal alcohol syndrome, there's no evidence that he's intellectually disabled. If anything, his IQ, even on Dr. King's testing, is average or above average. And no evidence of significant ADHD type symptoms or impulsivity. I don't believe we need criteria for that disorder.
Thank you. That's good.
Thank you. Defense Cross.
Morning. Morning. I want to talk first about your CV. And looking at your education, I'm not seeing any specialized training or certifications in treating children or adolescents with psychiatric illness. Is that correct?
I'm not board certified in child psychiatry. In general psychiatry, I think everyone does do rotations in childhood.
Your CV also lists that from 2017 to 2018, you were a staff psychiatrist at St. Joseph Mercy. Is that correct?
Correct.
During that 1 year, were you seeing patients
Yes,
in the hospital or in an office setting?
in the hospital.
Adult wing, or were you dealing with pediatrics?
Adult.
So since July of 2019 to present, you've been employed with the center as you described, correct?
Correct.
And you mentioned that you see patients that are hospitalized under court order, correct?
Correct.
And as well, you perform the competency and criminal responsibility examination.
Correct.
Would you agree with me that part of your job is to diagnose and treat mental illness?
Correct.
Are children housed at the center?
They are not.
You stated that you have performed 525 criminal responsibility exams. Is that correct?
Forensic evaluation.
Forensic evaluation. So that is a combination of both, correct?
And some other ones, we do perform or have performed other evaluations at the center in the past.
How many juveniles have you examined?
Probably less than 5.
How many juveniles charged with life offenses have you examined?
1.
Is that Mr. Crumbley?
Yes.
Is this the first time that you've testified at a Miller hearing?
Yes.
So before sitting in court and watching this hearing, were you familiar with the Miller factors?
I was. Yes.
How are the cases assigned to examiners at the center?
Mostly it is by random basis. We have a scheduling department that assigns the cases.
Were you aware that you were not the first doctor that was assigned to do the examination of evening published?
I was aware of that.
Did you speak to the doctor that was first assigned to do the examination?
Only to ask for the flash drive that was in his possession.
Did you discuss the facts of the case with him?
No.
Do you recall when you were assigned to this case?
In February of 2022.
Can you recall when you received the list of discovery items that you have noted in your report?
Again, the previous doctor who was assigned had the flash drive full of sources of information. So as to when he specifically gave it to me, I'm not sure.
So your report is dated March 29th of 2022, correct?
Correct.
You note that you spoke with Mr. Peace on 3-1 and 3-11, correct?
Correct.
You detailed your process of when you are assigned to a case and the steps that you take. What is the reason you would talk to the prosecutor?
In a case such as this, since I spoke with the defense attorney as well, I wanted to speak to see if there was any other additional information they wanted me to have before seeing the defendant.
So I want to go over what you did review. I added up, you had it broken down by page numbers. I have that you reviewed 3,136 pages of discovery. Does that sound about right?
Yes, I'll take your word for it.
Okay. It looks like 20,688 messages between the other juvenile and Ethan. The Google Android extraction report, you noted there was 1,072 images.
Correct.
270 minutes of video, which is roughly 4.5 hours.
Correct.
You then met with Ethan one time,
Correct.
and that's on March 15th.
Correct.
You recall the start and stop time of your meeting?
It was 5 hours long.
In the items that you considered, you list evaluation unit personal history questionnaire. What is that?
When every defendant comes to the center, they're given this questionnaire. It has basic information, historical information like their name, date of birth, age. It also has things like places of employment, and then the back is for if they've ever been to any sort of psychiatric facilities. While we inquire about all of that, it's helpful to have it written down in advance to see if the defendant specifically wants to discuss it.
Roughly how many questions does it have?
It's a front and back.
Okay. And do you have the patient completed in your presence, or is that something that's given to them prior to you arriving?
It's given to them prior to arriving.
And you would agree with me what you just described is a lot of self-reported information.
Correct.
So I want to discuss what you've reviewed regarding this case since your report was authored. Obviously, it was some time ago. So it's my understanding that you reviewed Dr. Kabir's records from day one of the jail all the way up until the start of the hearing. Is that correct?
What I reviewed is day one from jail all the way up until the time my report was authored. And then I was given additional records since that time, and most recently up to July of this year.
You stated you watched the video of Ethan in jail in the restraints, correct? And you aren't aware if there's any other videos of situations like that in jail. You were just presented with that, correct?
Correct.
You viewed obviously Dr. King's report and updated jail records, correct?
Correct.
And then you watched the testimony of Dr. King and Dr. King.
Correct.
You did not speak to any family members or Ethan's parents to either confirm or disprove anything that Ethan was reporting, correct?
No, correct.
Mr. Keys touched on this a little bit, but I think it's important, so I want to touch on it again. You would agree with me there's a few ways to diagnose mental illness or to assess mental illness.
Correct.
Okay. So we talked about looking at the brain directly, and that was not done, correct?
Correct, because it typically is not.
Okay. So if someone has a suspected brain injury or brain damage, you did say that imaging could be used, correct?
If there are signs and symptoms accompanying that, then we might consider brain imaging, yes.
You can test the brain using some of the testing that Dr. King used or that you mentioned, correct?
Correct.
And you didn't perform any of that testing, correct?
No.
Or you can use the symptoms that the patient provides, correct?
Combined with, again, our clinical judgment and the diagnostic manual and data. Yes, absolutely, that's important.
Okay. What is the DSM?
So diagnostic manual, it lists various diagnoses and the criteria that would be required to meet those diagnoses.
And what is it used for? Is it a tool?
It's again, a tool that we would use to help diagnosis.
Okay. And to diagnose mental illness, correct?
Correct.
Okay. Did you use it in relation to these facts and in this case?
Yes.
According to the DSM, the signs of major depressive disorder are depressed mood most of the day, feeling sad, empty, hopelessness, loss of interest in pleasurable activities, difficulty sleeping, agitation, fatigue, feeling worthless, thoughts of death or suicide. Do you agree with me?
I do.
You would agree with me that Ethan reported every single one of those symptoms.
He reported many of those symptoms, yes.
According to the DSM, what is the definition of psychosis?
Psychosis is a symptom of diagnosis. So there's schizophrenia in the DSM, there's schizoaffective disorder. Psychosis in and of itself is not a diagnosis, it's a symptom.
Okay, and can you describe that symptom?
Typically, like I mentioned before, it's gross impairment in recognizing reality.
What are delusions?
Delusions are fixed, false beliefs that are non-reality based.
Now, I want to go over your report. I know you have it with you. On page 7, you indicate that his parents' relationship was occasionally stressful for him. Is that correct?
That's correct, yes.
And he detailed that when he was living in Washington, and there was a situation that he recalls where he was very young and he heard his mother yelling on the phone in the middle of the night. His mother told him that his dad was missing, correct?
Correct.
And told him that his father was at a waterfall and there to commit suicide, correct?
Correct.
And it's your understanding, or at least what Ethan relayed, is that he was then put on the phone with his father and he was crying and telling him to come back home and to not kill himself.
Correct.
He also told you that his parents argued a lot.
Correct.
Now, moving on to page 8, you discussed preschool, and this has been discussed previously. He relays to you that he recalls in preschool where he's outside during recess and he's watching cars go by, and he says to the lunch lady, "Man, wouldn't it be cool if the cars crashed and blew up the school?" And the lunch lady was upset by that, correct?
Correct.
And he told you that's when he realized maybe other people didn't think about the things he thought about.
Correct.
So I want to go over what you have, I think it's psychiatric history, page 9. He recalled his parents giving him half of a sleeping pill of his mom's prescription twice, correct?
Correct.
And he detailed that he had some sort of attack. And his parents reported to him that he was doing all this crazy stuff and saying, "I see someone," and he was walking in the driveway in shorts, correct?
Correct.
And obviously, you've reviewed the text messages, but did you review the text messages between James and Jennifer?
Some, yes.
Okay. Do you recall reviewing the text message where they actually talk about this incident?
Yes.
Okay. He told you that he recalled asking for mental health within the last year, mental
Yes.
health care. And he detailed that on his 15th birthday, he got really upset and said, "I want to see a therapist." You recall
Yes.
that? And he explained to you that at that point, he didn't want to move forward in life.
Yes.
I wanted to stay at that point. So when I realized I'm getting older, I needed help to get past that. Is that what he reported?
Correct.
And to your knowledge, he never saw a doctor or counselor, correct?
Correct.
You then discussed suicidal thoughts. He reported that he had suicidal thoughts for a year since 9th grade and actually one suicide attempt, correct?
That you reported, yes.
And that was in October of 2021?
Correct.
And he detailed that he took 8 to 10 allergy pills. He was really sad and anxious about moving forward and getting older, correct?
Correct.
And he details that he falls asleep and he wakes up the next morning sick.
Correct.
You then talk about the voices that I know Mr. Peace asked you about, and you spend a good deal of time talking about that. So he told you that he occasionally hears external voices, variably a man or woman's voice calling his name, correct?
Correct.
He heard external voices for a week or two when in jail after the offense, but stopped when he was on constant watch.
That was his report, yes.
He then tells you once he was taken off constant watch, he began hearing them occasionally, correct?
Correct.
And there was an incident where he heard, "Ethan, can you hear me? Ethan, where are you?"
Correct.
There was also conversation about an internal voice, correct?
Yes.
And he described that as he felt like it was his own voice, but it was the bad side of him.
Correct, like a conscience.
And he said the thoughts that are bad.
Correct.
And he told you that the internal voice is currently not as bad as it was before, and that he's fighting it every day.
When I saw him at that time,
Yes.
yes.
Now, you stated you went through these text messages. Did you go through the web browser history?
I did, yes.
Okay. The journal, the video he made the night before, the assignments, the emails from teachers asking that Ethan be seen by a counselor.
Yes.
Now, in your report, you picked specific messages from the other juvenile and Ethan to put in your report, correct? You obviously didn't list all of them. Correct. Okay. And you picked out what best suited your analysis or best suited your opinion, correct?
No, I tried to include every instance where he discussed mental illness at all.
And obviously it was to support your final conclusion, final opinion.
It was a source I used, again, as data, but I would never pick out ones just to support my own conclusion.
In your report, Ethan details that in 8th grade, he was shown his first graphic video. Do you recall?
I do.
And someone showed him the video of a guy blowing his head off.
Correct.
And he detailed to you that he couldn't stop thinking about it. And a few weeks after seeing it, he started to get interested and then looked stuff up himself, correct?
Correct.
And he told you that he was addicted to watching videos of war and people die.
Correct.
Now, you go over the issue with the birds in your report on page 37. And I know that Mr. Peace asked you tension release, and you said you didn't agree. Well, on page 37, Ethan tells you, I felt a relief feeling, a feeling in power, correct?
Correct.
He then details after 9th grade concluded, he recalled lying in bed for 3 days straight, watching movies and TV, correct? Correct. And he stated that he was only getting up to go to the bathroom or to get something to eat, correct? Correct. You then move forward in time. So we're looking July, August of 2021. He tells you he had no social interaction with anyone other than B, his juvenile friend, correct?
Correct. So again, when you look at the actual context, he was also interacting with his parents at that time and going to work.
And he told you that he felt like a person living in a house, eating food with no other purpose.
That was his retort, yes.
He told you that in my head, I kept going, you are doing nothing. You have no future. I was trapped. I didn't know what to do for the future. I was doing bad in school. I had no purposes for school, but didn't want to drop out because I would have no job or career. So I thought these last years of high school were the only years you have left until you are dead or homeless.
That's what he said, yes.
He told you he never really hung out with his parents, correct?
I don't know if that's true. He told me he went camping with his parents in the summer. He might have said that later, but again, he said many things during our interview.
So on page 38 of your report, right under the quoted portion, it says, Mr. Crumbley was asked about the involvement of his parents that summer. He stated he never really hung out with his parents, though he endorsed occasionally playing board games and camping with them. Correct. Okay. So now moving forward to Halloween of 2021, he told you that his one and only very true friend left, correct?
Correct.
And that it was a somewhat sudden departure.
Yes.
Okay. And he told you that without B, I had no friends, no social contact, and I hated school, correct?
Correct.
He told you that his mom understood that he was upset because he started acting differently.
Correct.
He told you that his mother said they were going to mess with B and that he won't want to be my friend anymore when he comes back. They would manipulate his brain. Correct. Even if he did come back, he thought that B would not want to be his friend. Correct. He told you he had no one to talk to, so that's when he turned to his journal and his cat. Correct. You then go over, I think, what you call planning. He had told you that he had planned the shooting in his head, but that he never thought he would ever get that far, correct? Correct. He tells you when he got the gun, he was like, I have it, let's do it. And I was like, it's a crazy idea, but it just kept coming. Correct. Now let's talk about the day before the shooting. He told you that he brought a live round to school and actually showed his classmates, correct? Correct. He told you that he wrote in his journal that he was going to do the shooting the next day. And while writing in it, he was so sad that he cried on the book, put his head down and cried in class, and no one noticed, correct?
That's what he told me, yes.
He also told you that he felt like the thoughts to shoot the school was as if I was a prophecy of my future and I had to fulfill it, correct? Correct. You gave us your definition of delusions, and it's your opinion that that is not a delusion, that he had to fulfill a prophecy?
No, because again, those are words that he used, but at no time did he ever tell me that he shot the school because of a prophecy. He wasn't saying that, he was saying it was like a prophecy. Again, it's different having a fixed belief and using a turn of phrase to describe something.
So he told you that he was looking up bullets at school, he was called to the office, and he was never asked if he had access to the gun, and they let him go, correct?
Correct.
He stated that day he was walking home and he began to think, no, I'm not doing this. B may come home and the girl I had a crush on might like me. Decided that he was not going to do it. He had good thoughts about not shooting the school, and those began working, correct?
Correct.
And then he details he gets home and unfortunately he has a very difficult night because there was a horrible argument with his parents, correct?
Correct.
His dad called him lazy. And he just.
Yes, yes.
I apologize. And he described to you that they had arguments in the past, but this one was really, really bad.
Correct.
And he stated to you that the thoughts of the shooting came back in an instant.
Correct.
And the good feelings he had when walking home just evaporated.
Correct.
So he describes the morning of the shooting. He told you he woke up feeling sick, like he had the flu.
Correct.
He actually went to the bathroom to puke, but nothing came out.
That's what he told me, yes.
He told you that he walked to school. He was quiet and sad.
Correct.
He told you that he was typically putting all of his bad thoughts in his notebook where no one can see it, but on that day, he drew it on a piece of paper so his teacher would look at it.
Yes, exactly.
And he told you that part of him wanted to get caught, the other part didn't want to, correct?
Correct.
Then he described the moments leading up to the shooting. And he told you the thought, you asked him, I think, what was in your mind or what were you thinking about as you exited the bathroom?
Yes.
And he told you his thoughts were, don't do it, don't do it. You are not going to do it.
Correct.
And then he describes to you that he started firing the weapon.
Correct.
He told you he wasn't even looking at the people, he was looking at his hand, correct?
That's what he said, yes.
He also described the scene in the bathroom at the very end of this incident. And he tells you after shooting the person in the bathroom, at that moment, it came back to me, like what I did, correct?
That's what he said, yes.
And he told you that the second person was scared and I felt bad, like Jesus Christ. I said, I can't do this. So I escorted him out of the stall. I didn't want to hurt him, but I didn't want him to attack me. And I told that person he could go, correct?
That's what he said, yes.
He then told you my thoughts came back, like what have I done? So I walked out of the bathroom, correct?
Correct.
Unloaded the gun and put it on the trash can outside of the bathroom.
Correct.
He saw the police and he surrendered.
Yes.
You spent some time going over like remorse or regret or feelings like that, and he told you, I felt like I had to say I was remorseful when it first happened, but that's what I actually feel now.
Yes, that's what he said.
Now, there's a large section in your report that details information that you gathered from the Oakland County Jail. And you indicated that you reviewed notes from a caseworker, and you actually dictate a number of those notes in your report. I think it's 7 pages, correct?
Correct.
Do you recall the name of that caseworker?
No, I don't.
Did you ever speak to that caseworker over the phone?
No, I just reviewed her records.
Do you know what that caseworker's training was?
No.
Do you know if he or she was a psychologist, psychiatrist, or had any sort of training in dealing with children with mental illness?
Typically, if they're jail mental health staff, they have some training as a mental health professional, but no, I don't know her exact qualification.
Okay, and you couldn't confirm it, right? You don't know.
We don't typically call, we just review the records.
So when you spend 7 pages of your report detailing what this person notes, you would agree with me that you relied on this reported information when forming your opinion.
In part, yes. Again, many pieces of data. The jail psychiatrist records are also in there, as well as information that the defendant exchanged with people outside of the jail. So the Oakland County Jail report section that I dictated or that I wrote is multiple people, not just this caseworker.
Okay. But in my review of it, I think there's at least 7 pages of when you're dealing with the caseworker, and I think there's 1 sentence about Dr. Kabir. So when this caseworker reports that he's not hallucinating or he's not responding to internal stimuli, again, you don't know what type of training this person has to make those calls, correct?
Are you saying that they're not a mental health professional counselor? Because again, I don't know that they'd be employed as a mental health professional at the jail.
Correct, you don't know, correct?
Again, usually in their signature, they write that they're a qualified mental health professional, like a QMHP. and most jails have that qualification. So I don't know if she's again, I doubt she's a psychologist or psychiatrist, but I review all of the data from the jail, including the caseworkers who regularly see people on the mental health board.
So you state in your report that you reviewed Dr. Kadir's records from 12/3 to 3/14, correct?
Correct.
And now obviously I understand that you've reviewed them moving forward.
Correct.
And in one line on page 57, you note the psychiatric documentation lists Mr. Crumbley's diagnosis as major depressive disorder, recurrent episode severe, correct? You do not spend 7 pages or any pages going over Dr. Kadir's records, correct?
Her records are absolutely included. I don't spend 7 pages because she sees them less than the caseworker who saw him daily. So again, it's all proportional. And Dr. Kadir's records, again, what I'm writing are the highlights for diagnosis, for interactions with them. And I would note any sort of psychotic behavior that she exhibited or thought he exhibited if it was present, and it was not.
You would agree with me, though, that having another psychiatrist meeting with him daily and then weekly, her reports and her findings would be important to you, correct?
Absolutely.
Did you not include more about Dr. Kadir's reports because you don't agree with it?
No, absolutely not. I don't put out information that I don't agree with.
You believe Dr. Kadir is wrong in her diagnosis?
I believe the defendant absolutely could have developed a major depressive disorder after time in jail in isolation. But what I was opining on is whether he had a statutorily defined mental illness at the time of the shooting. So I don't necessarily disagree with Dr. Kadir, but that opinion is different than the opinion that I'm giving.
And you would agree with me, though, looking at her records from the very start, just days after he was incarcerated, she's already diagnosing him with this major depressive disorder, correct?
Correct. And I would also just note, though, that Dr. Kadir, as a jail psychiatrist, is not forensically trained. So our training may have been different, and thus our conclusions may also be different.
You have come to know that he is currently on multiple prescription medications to treat mental illness and anxiety, correct?
Correct.
It was your testimony that you are in a better position to diagnose him after your one-time visit with him in March than the doctor who sees him every week?
No, because again, those medications that he's on have been added over the months that he's been in jail and years. So whether he has, again, depression, major depression, an adjustment disorder, I believe she diagnosed him with, whether he has that now, after a year of being in a jail cell by himself with the enormity of his charges, that's different than, again, from that statutory definition at the time he shot the shooter.
But you would agree with me, her diagnosis came very early in the first few days she visited with him, correct?
One of her diagnoses did, but
Yeah.
she didn't place him on medications for months.
Well, I believe there is dictation in her report stating that it was discussed and it was Mr. Crumbley who was saying he didn't want medication, correct?
In part, but a lot of the medications he's on now were never discussed at the beginning.
Are you familiar with the PHQ-9 score?
I am, yes.
And in reviewing Dr. Kadir's records, do you agree that it appears that he has made progress in relation to that PHQ-9 score?
Yes, that's a self-report. It's a checklist. And yes, over time, that number has gone down in her records.
So you would agree with me that one of the first tests in February of 2022, he scored in the moderately severe active treatment psychiatrist and therapy, and then was then scored months later as mild, correct?
Correct.
I want to discuss the definition that you have in your report of mental illness. In your report, it states a substantial disorder of thought or mood which significantly impairs judgment, behavior, capacity to recognize reality, or ability to cope with ordinary demands of life, correct?
Correct.
And in your opinion, you found that Ethan did not have mental illness as defined by statute.
Correct. At the time of the offenses.
Correct. You then state, I recognize my opinion on this matter requires significant clarification. Why did you write that?
Because I could see that the perception of someone who's writing that they have hallucinations and writing that they have low mood and suicidal thoughts, when you read just those things, it comes to mind this person is mentally ill. So that's why I felt it required significant clarification to explain why that may not meet the criteria and why some of the things that he was reporting do not meet actual clinical diagnosis.
You say, I acknowledge that there is data that taken on the surface could initially suggest that Ethan experienced symptoms associated with a psychotic disturbance around the time of the offenses. You go on to talk about the text where he's talking about ghosts or demons, external voices and shadows, hallucinations, the video the night before where he talks about those three voices, talks about a demon. But you state that, and I think you mentioned this earlier, you rationalize it with, well, the belief in a haunted house is not in itself a mental illness. So it's not uncommon when someone is watching scary movies. So you're telling me each and every time that he has these incidents where he's either texting his mother or he's texting V, his juvenile friend, about things flying off the shelf, or doors closing, things falling, hearing footsteps, a toilet flushing. Your explanation of that is he must have been watching scary movies during every single one of those events, and that's why he's reporting them.
So he's not watching them every single time, counselor, but he is watching them much of the time. And the other times, you need to look at the context of how he is acting outside of these self-reports. There's no report from, again, or there's no kind of clinical data in terms of hallucinating in Spanish class and having someone else see that hallucination, or being at work and having your friend also hallucinate it. So no, he's not watching horror movies every time, but when you look at all these different instances, there's just, it doesn't line up with true psychosis for all the reasons that I mentioned.
The things that he does describe, like we just talked about, could be delusions or hallucinations. They could be.
It could be. I don't feel that the evidence supports that.
Now, the conversation or the mention that you made in your report about the voices. In the video, he says the voices are me. I am the voices. So these voices are his conscience rather than a psychotic illness. Is that what your opinion is?
In part, again, I asked him very specifically about those statements in the video, and he at no point told me that he was hallucinating when he made that video. He wasn't hallucinating on the day of the offense, and he wasn't hallucinating for days prior. So even if you take his hallucinations at face value, which again I disagree with, but even if you do, he specifically told me he wasn't psychotic or hallucinating in and around the time of the offenses.
Did you tell him what the definitions of those big words are? He's 15 years old, obviously doesn't have medical training, so.
No, that's exactly right. That's why I don't think that he was lying. I think he was misusing a clinical term, and that's why we as medical professionals have to tease that out.
So the voice that he talks about, not only in his journal, but also in that video, you're saying it's his conscience, correct?
Are you talking about what he calls the internal voice?
The internal voice, yes.
Yes, I do believe it's most consistent with something like a conscience. He identified it as the bad thoughts that he had had since he was a young child. And so again, he very specifically told me it's my voice, it's not an external voice, it's what I think about.
Okay. So is it normal that a 15-year-old boy has a voice in their head telling him to kill?
No, it's not normal. But the question is it psychotic? And the answer is no.
So I understand that everyone has a conscience. I mean, for example, you're approaching a yellow light. You have a quick dialogue in your head. I really need to get home. I'm late, but I don't want a ticket. So are you telling this court that it's normal in a scenario for someone's conscience or internal voice to say, run the red light, hit as many cars as possible, swerve toward the kids in the walkway, don't stop for police? Is that normal?
I don't think anyone would say that the violent thoughts or desires to kill and torture that the defendant was having were normal. But we have to differentiate what is not normal from what is a clinical, statutorily defined mental illness. So in no way am I saying that those thoughts are normal or good, but they are also not psychotic.
Hearing a voice in your head telling you to do bad things could be delusions, could be psychosis.
It wouldn't be a delusion because that's not the definition of that. And again, a voice could be psychotic, but in this case, it was his own voice saying what the things that he liked to do in terms of the violent thoughts. And I don't believe it was psychotic.
So you say that there is no indication from objective sources that Ethan engaged in unusual behavior that would be typical of psychosis, correct?
Correct.
So again, psychosis is a disconnection from reality. Symptoms are delusions, hallucinations, talking incoherently, and agitation. It can cause one to harm themselves or become violent towards others. Would you agree with me?
I would, though some of those terms are very general, like agitation. That could be psychotic. It also could just be agitation. So there, again, it kind of depends, but generally, yes. I don't know.
And after everything we just discussed, you don't think that's what we're looking at here?
I do not, no.
So the jail staff, you indicated that they never reported that he was responding to internal stimuli, and Mr. Peace had you define that. You would agree with me that not everyone who is responding to internal stimuli has visible symptoms, correct?
Responding to internal stimuli by definition is visible. So again, like if someone is actively hallucinating, what we typically see are visible signs of that. Again, the distraction, the difficulty in attending to a conversation, the speech disorganization. It would be quite atypical for someone with psychosis as severe as what is being postulated to display no visible signs.
Is there always signs and symptoms of mental illness at all? I mean, can someone have mental illness and you look at them and you would have no idea? You would agree with me there?
Absolutely, but that's different than what we're talking about here.
I agree, it's different than psychosis.
But yes, absolutely. You can't just look at someone and necessarily tell that they have depression or anxiety.
Okay. You stated that you believe the motivation for his shooting did not appear to be based on a delusion or a psychotic process. And you have in your report that Ethan felt like the thoughts to shoot the school was as if I saw a prophecy of my future and I had to fulfill it. I want to go over that again because you're saying it's not based on delusion, it's not based on psychotic process, but then he believes he has to fulfill a prophecy.
Again, I think the wording is very important, counselor. So he's saying it's as if I was having a prophecy. That's a turn of phrase. He at no point during the interview told me I had to shoot the school to fulfill a prophecy. He told me that he had been thinking about this for months and months, not because of a prophecy, but because he had been thinking about it. So when I asked him specifically, why did this happen? Were you hearing voices? Did you have any beliefs about it? He didn't keep referring back to this idea of a prophecy. In my analysis, that's very much a turn of phrase and not a delusion.
So obviously when you begin your interviews, you explain to the patient why you're there and the purpose of the interview, correct?
Correct.
So Ethan obviously understood what it was for.
Correct.
And obviously if he wanted to make himself out to be mentally ill at a higher degree as a way to minimize his actions, obviously he could have reported some very, very heightened symptoms, correct?
Correct.
Could have told you aliens and ghosts made him do it. He could start talking to voices while you're present with him, correct?
Correct.
And he didn't do that.
No, I didn't believe he was feigning or malingering at all.
And you have had interviews, I'm sure, where you believe that a patient is over-reporting or is saying things that you don't believe are true, correct?
Absolutely, yes.
And really what he told you in that interview did match up with the text messages to be, correct?
Correct.
The text messages between James and Jennifer, the one about the specific incident, correct?
Correct.
The fact, what he was Googling, what he was looking up, the videos he was watching, what he was writing in his journal, correct?
Yes, I felt he was very forthcoming.
And you agree with me that when you look at Dr. Kadir's records, he's reporting the same things there as well.
In terms of all of those things,
Correct.
I don't think we've discussed all of them, but yes.
So you would agree with me, what Ethan has reported has been pretty consistent.
Yes.
So you mentioned the testing, and you stated that testing only shows the symptoms on that day, or more closer in time to the exam rather than to the incident, correct?
Yes, what I said is that you can't necessarily extrapolate any results from a psychological test you do later and say it definitively proves they were thinking that 6 months prior or a year prior.
Okay. And I understand that, but again, you would agree with me, he's reporting the same things.
Yeah, so what I would say is that I think absolutely his symptoms worsened once he was in jail and in isolation in a jail cell. So like, yes, he reports the same things in terms of depression, but the experience and life that he's in now is very different than what he was in November. So I don't think that you can correlate the two necessarily.
So again, I want to talk about the possibility of over-reporting, the possibility of having a patient come before you and tell you things that you don't necessarily believe, okay? And you stated you have had patients like that, correct?
I have. I didn't feel like this defendant was.
Okay. You actually testified in the case of People versus Callum in December of 2022, where you discussed this same issue, correct? About over-reporting?
Correct.
And in that case, you were performing a criminal responsibility exam, correct?
Correct.
And in that case, after your initial evaluation, you had concerns that the defendant was not being truthful.
Correct, because in that case, very different. What he was telling me during the evaluation made me suspicious from malingering. So that's why I got a psychological test to see if he was malingering in that moment when he was speaking to me.
Okay. And you testified that one of the signs that you look for when you're concerned with a patient feigning or intentionally producing symptoms of mental illness is them thrusting their illness forward in your face. Like, I want to tell you about this, correct?
Correct.
Okay. Ethan didn't do that, correct? He waited to be prompted and answered your questions.
Correct. As already stated, I had no suspicion that he was malingering during the evaluation.
Also in that trial, you testified self-reporting may not be reliable when different things are told to different people. We don't have that here either, correct? He's reporting the same thing.
Correct. He's been consistent.
You testified if someone had true mental illness that was a psychotic illness, one would expect that the person had symptoms prior to the crime or prior to the incident, correct?
Correct.
And your testimony is that Ethan had no symptoms that were psychotic nature leading up to November 30th. Is that correct?
That's correct. Again, counselor, he reported psychotic symptoms, but we have to do more than take self-report at face value. And when we use our clinical expertise and judgment to examine what he reported prior to the offense, because I acknowledge he reported it prior to the offense, it just simply doesn't match up with true clinical psychosis.
And in that case, People versus Callum, after your initial interview, you had him seen by a psychologist for testing, correct?
Correct. Again, because there was suspicion of malingering at the time that I saw him.
And you testified that a psychologist doing testing can be one piece of helpful data as you come to your opinion. Do you agree?
Absolutely. Again, one piece of data.
And in that case, you had Dr. Shields, I believe that is a doctor also at the center, correct?
Yes, she's a psychologist.
Okay. You had her perform the MMPI-3, correct?
Correct.
Okay. You do not have training in performing these tests or reading the results, correct?
The way that we do it at the center is that psychologists are the ones performing and interpreting the testing. We as psychiatrists certainly refer for testing and consult with the psychologist on what question we have and what tests we think are legitimate to answer the question. So it's not that we have no training on it. We're certainly familiar with the tests and the results, but at the center, the psychologists conduct the tests.
Okay. And are you familiar with that MMPI-3 test?
I am.
Okay. So not only is it a 330 question test of self-reporting signs and symptoms of mental illness, there's a validity scale built in.
Yes, it's one of the ones of Dr. King's testing, the majority of which do not have them. That is one of the ones that did.
Okay. So it shows the score as it relates to the self-reported information, but then also gives you a score or indication as to whether the symptoms that are being reported are feigning or untrue, correct?
Correct.
Do you agree that any score above 60 causes some concern or notes that there's some psychiatric things going on there?
Correct.
Did you,
Again, it depends on what scale, but yes.
sure. Did you go over the results of that test?
Yes.
Okay, I'm going to draw your attention to page 35 of Dr. King's report.
Okay.
Actually, let's go to 34 first.
Okay.
Like, which version are we referring to?
The one that was admitted by myself.
Would that be 63?
Your Honor, it would be in my defendant's exhibit binder, which is exhibit N as in Nancy.
Thank you.
So let's look at 34. There is it looks like a validity scale. Is that correct? Okay. And following, there is some statements. It says a review of the validity scale indicates Ethan's T-score is 48, which is an indication that his responses were in the normal range for inconsistency reporting. Correct? Correct. Okay. So again, we're looking at anything above 60. So let's go through the results here. So it's still on that page on 34, it says Ethan's score 75 is elevated infrequent responses. Let's go to page 35. So let's go through the actual scores. So a review of higher order and restructured clinical scales indicates elevations of EID, which is emotional internalizing dysfunction. We have a score of 75, correct?
Yes, so I would just note now the scales you're talking about are a little different, but.
Okay. We have under thought disorder, score of 85.
Correct.
Demoralization, score of 79.
Yes.
Ideas of persecution indicated when someone feels he is devalued, trapped, constantly persecuted with no means of escape. We have an 80, correct? Correct.
I'm sorry, Ms. Lawson, before you move on, let's just start with page 34. I kind of went.
35, I apologize. What I just read was on the bottom of page 35.
Thank you.
Let's move to page 36, the bottom. Helplessness and hopelessness, score is 70.
Yes.
Obsessive compulsive, score is 80.
Yes.
Following page 37 at the bottom. Negative school attitude, score is 65.
Yes.
Family problems, score is 80.
Yes.
Page 38 at the bottom. I don't know how to pronounce the word that is in quotations. Can you help me?
Are you talking about
In parentheses?
psychoticism?
Yes.
Yeah.
I was going to butcher that. So, which is indicative of someone who has pervasive and intrusive thoughts. His score is 80, correct?
Correct.
You would agree with me that this test can give you some good information, correct?
Absolutely. It's one piece of data to consider.
Again, you did not have this test done with Ethan, yes or no?
No, because again, it shows what he was experiencing and reporting at the time the test was given.
You did not have any psychologists come and do any type of testing with Ethan, correct?
No, I do not.
Let's go back to your report. You state on page 62. It is my opinion that there was no indication that these reported symptoms of depression were severe enough to significantly impair his judgment, behavior, capacity to recognize reality, or his ability to cope with the ordinary demands of life at the time of the alleged incident. Correct?
Correct.
I want to talk about the ordinary demands of life. There is a lot of text messages, writings in his journal, in the video about school, specifically about college, the progression of life from being a kid. In review of everything, that is a huge issue for Ethan, correct? He can't get over the fact that he's going to get older, things are going to change, that he doesn't have a plan, that he's going to either be dead or homeless, correct?
He reported that, yes.
Okay. Obviously, growing up is a demand of life.
I suppose so.
And it's still your opinion that you feel he was able to cope with those ordinary demands of life, even though he mentions that he is so struggling with them in multiple avenues.
Yes, because again, when you look at his functional status in his life, he's reporting these things. But when you look at what he's actually doing on a day-to-day basis, I don't believe he met that functional impairment criteria.
But you're aware he quit the bowling team, he stopped working, and once his friend was there, he essentially would go to school and come home, and that's it.
Well, again, even in the month after his friend cut off contact, even in that month, he was doing things that brought him pleasure and that he engaged in terms of other hobbies and activities. He was future oriented, which is another thing that we look for when we look at major depression. So he was hopeful that a girl in school that he liked him back. And he even mentioned how the day before the offenses, that almost caused him, in his own report, to not go through the shooting. So he was future oriented. He was doing things that he thought were fun. When you look at his daily activities, no, I don't think that he meant that.
When you say future oriented, he talks about going to prison. Is that what you consider future oriented? He's looking forward to that?
So he was very aware of the consequences of his behavior.
Let's talk about the lack of sleep. You stated, obviously, in looking at those text messages, you can see that he is texting very late into the night, correct?
Yes, absolutely.
And your opinion on that is, well, basically it's chronic. It's not something that just occurred around the crime. So really that doesn't play into your opinion.
No, it did play into my opinion. What I was looking at specifically is whether he exhibited signs of mania, which often, would fit criteria for that major mood disorder. And when we look at his sleep patterns, not only were they chronic, but he had what's called very poor sleep hygiene. So he was drinking liters of Mountain Dew every night, or frequently at night. He was staying up very late and then sleeping during the day. There's text messages with his friends, even in the months prior, that he said that he's basically nocturnal. So not necessarily that he was getting no sleep, it's that his sleep schedule was altered. And when you look at something like mania, that's a decreased need for sleep where someone's not feeling tired. And that's not what we saw here. This wasn't a decreased need for sleep. It was a poor sleep hygiene with sleep at different times of the day and not consistent with the day.
Obviously, in looking at his attendance record, he was attending school extremely regularly. So if he's up till 1, 2, or 3 in the morning, obviously he's then at school at 7:30 or 7:45, correct?
What he told me is that in the summer, he was nocturnal. He was sleeping during the day. And then as school started in the fall of 2021, he would go to bed late and wake up about 4 to 5 hours later, getting that less amount of sleep, but he would feel very tired. That's a differentiating factor from something like mania, where the person feels like they don't need to sleep. They feel like they have tons of energy despite getting inadequate amounts. So this was not that. He was quite tired and feeling the effects of that.
Okay. You would agree with me that obviously the brain needs rest and the brain needs food to function properly.
Sure.
I want to talk about your comment about the violent thoughts. You stated that violent thoughts have been present since preschool. I'm talking about page 67. And he had previously dealt with them in other ways instead of carrying out a mass shooting. So you list that he dealt with those violent thoughts by playing video games, by killing animals, and going to a shooting range or watching movies, correct? Yeah. I need help understanding this because you say he does not fit the definition of having mental illness. And then you say he's been able to control these violent voices by killing animals. So he should have been able to stay home that day and torture a bird instead of doing what he did.
So again, counselor, I understand it's very hard to imagine how someone who's sane can torture animals and who can commit mass murder. But the fact remains that they are, and they do. It's not everyone who tortures an animal, it does it because of psychosis or because of mental illness. It may seem completely horrible or illogical to people who are not in that situation, but it doesn't automatically equate to mental illness. So the point I was making in this paragraph where I was talking about his ability to conform his conduct to the requirements of the law at the time of the offense. What we mean by that is, did he have alternative courses of action that he could have chosen instead of shooting the people at the school? And he demonstrated he had multiple alternatives. We might not agree with them, but he was able to deal with those urges in other ways rather than killing people. And that included killing animals. It's not great, but he was able to do things other than killing people, and he chose not to.
You stated in your report that Mr. Crumbley's comportment with police and jail staff following the shooting suggests that he is able to engage in appropriate behavior surrounding this period of time, correct?
Correct.
And again, I know we talked about this before, mental illness presents itself in many ways, correct?
Yes and no, counselor. If someone's acutely psychotic, that presents in a typical way. So yes, everyone is different, and anxiety might present differently than depression, but there are set things that we expect clinically if someone is acutely psychotic and who did not display any of it.
Okay, so I asked more specifically just about mental illness.
Sure.
So psychosis isn't the only type of mental illness. You would agree with me?
Correct.
Not everybody with debilitating mental illness is walking down the street and talking to voices. You would agree with me?
Correct.
Okay. And I believe you touched on this before. A psychotic episode doesn't last perpetually, correct? It's not forever.
Correct.
So someone may be having a psychotic episode and then return to reality.
Not in the way that this was displayed, no. Because again, without intervention, without some sort of antipsychotic treatment or psychiatric intervention, it would be very atypical for someone to be acutely psychotic and hallucinating and show no signs of that afterwards or in the days, weeks, and months following the events.
You testified earlier that there was no bizarre behavior. Is your testimony that shooting fellow students is not bizarre behavior?
Not in a way that indicates mental illness, no. Again, we're not saying that it's good behavior or that it's normal behavior, but not all murder, not all violence is attributable to mental illness.
I want to finish with talking about the form of your report. You would agree with me that when you're doing a particular examination like the one you did here for criminal responsibility, there's a form or a rubric that is used.
I don't know if it's a rubric, but yes, we have reports with standard language, for example, the statutory language that is similar from one report to the other.
Okay. And would it be fair to assume that when you started with the center, you read other people's reports or you became familiar with how other doctors were doing their reports?
Yes.
Okay. I want to go over another report that you completed. Because of the sensitive nature, obviously, of the defendant's name, I'm just going to call him MC. May I approach the witness, Your Honor?
Yes,
I don't intend to admit this.
thank you.
When you have a moment, can you review that report and see if that is one that you authored?
Yes, I did.
So I'd like to compare the reports that you did for Ethan and this other defendant that we're calling MC.
Okay.
So if you could go to the first page of the report, and Your Honor, I will always give you the report pages for Ethan, since that's the report that you have in front of you.
Thank you.
So page 1, the bottom of the first paragraph, you would agree with me that in both reports you write, this report summarizes findings from his or her evaluation and my reasoning with respect to my opinion regarding his mental state at the time of the offenses referenced above. You would agree with me it's the same in both reports?
Correct, because the purpose of the evaluation is the same.
Let's go to page 57 of Ethan's report. And we're looking at page 19 in the report of MC. Obviously, you stated, you quote the exact same applicable statute, correct?
Correct, the statute is the same for criminal responsibility violation.
Page 58, section under conclusions and opinions relative to criminal responsibility. That is page 19 in the other report.
Correct.
You would agree with me, the paragraph begins to reiterate, according to Michigan law, a person is deemed, and it goes on. You would agree with me that that section is completely the same?
Judge, I'm just going to object to the relevance. I believe what counsel's trying to do is show that this doctor's own work product, her own work product, is similar to her work product in this case. When Dr. King testified, he was cross-examined about taking the conclusions of Dr. Carol Holden and adopting them as his own, and then testified it was the rubric, and that's why that happened. This line of questioning has no relevance to that topic because this is Dr. Anker's own work product. So I get it.
Thank you. Your response, relevant.
Your Honor, in response, obviously they were attacking Dr. King because the report was similar to someone else's report. The point of what I am going through here, and I can speed it up to the opinion that she has, it is the exact same wording, and that was attacked very, very harshly when it came to Dr. King. So whether he was using a rubric from a different doctor or using a report from a different case, it is a different case and a different set of facts. So if the summary opinion that she has signed here is the exact same in this other case that she has reviewed, I believe that it's relevant.
Thank you. If you could please get to the point, I'm going to sustain the objection, but you may ask a question about the conclusion.
Of course. Let's move to the opinion then.
Yes, glad.
Let's go to opinion regarding mental illness.
Yeah.
That is page 59 on Ethan's report, page 20 of NC. You would agree with me that both reports state regarding the question of whether you substitute a new patient's name in, had a mental illness as defined by statute at the time of the alleged incident for which he is charged. It is my opinion that he did not. Correct.
Correct, because I also thought that patient did not have a mental illness. That's just stating my opinion.
Sure, and it's the exact same sentence structure, the exact same sentence, correct?
All it's stating is regarding.
I'm asking yes or no. Is it
Yes.
the same?
Yes.
Let's move then to opinion regarding relevant capacity.
Okay.
That is page 64 on Ethan's report, page 24 on the other report. You would agree with me that it is the exact same except the name is switched.
It's a restatement of the statutory guidelines.
I'm asking yes or no. Is it the same except you switch out the name?
Yes, because the statutory guidelines are the same.
Let's move to the very last page of your report.
Okay.
And of Ethan's report, summary opinion. Would you agree with me? It is word for word the same, except you switch out the person's name.
Because it is relisting the statutory.
I'm asking yes or no,
definition of
ma'am.
illness. Yes, Counselor.
And that is your summary opinion. It is the exact same in both cases. You're switching out the name.
Because you can't change the statute. The definition is the same, no matter how you write it. So what I am restating in my summary opinion in both cases is that I did not believe the person met the statutory definition. So yes, it is the same.
I have nothing further. Thank you
Before
very
you
much.
sit down, I had a question.
Yes.
Going back to Dr. King's report, you had started at page 34 under the validity scale. I'll allow the doctor an opportunity to get there, specifically page 34 of Dr. King's report.
Okay,
Please let me know when you've gotten there.
yes.
It says a review of the validity scale VRIN-R indicates Ethan T-score is 48, which is an indication that his responses were within the normal range for inconsistency reporting. What does that mean?
So there's multiple scales on an MMPI, some measure for over-reporting, some measure for consistency in responses. And what that is saying is that his responses weren't inconsistent. They were in the normal range for consistent responding.
Thank you. And it goes on to say Ethan scored 75 on the F-R. Infrequent responses is elevated, indicating over-reporting of clinical issues. What does that mean?
Yes, so what that means is that the test showed some evidence that he was over-reporting his clinical symptoms.
Thank you. Defense, any questions based upon the court's question?
And the reasoning that you didn't have this MMPI pre-test done is because you did believe Ethan and the symptoms that he was reporting, correct?
I did not think he was saying it.
Nothing further.
Thank you. People
Thank you.
redirect.
Thank you. Doctor, you're the same person today as you were in March 22, right?
Yes.
So this report in June 1st, 2023, this is your work product.
Yes,
Okay, and there's only one statute defining mental, is that correct?
correct.
And in fact, you're actually duty bound to follow that statute.
And to cite it several times in my report.
And that is the statute. That's the only statute that guides you in this analysis. Is that correct?
Correct.
So when you're being asked if it's the same language verbatim, it's because that's all that's there. Am I right?
Correct. There's no other way to state that.
Okay. Now, we shouldn't get too much into detail on this other individual, but you did indicate that opinion requires some clarification. Just tell us why.
Are you talking about this report?
This
or the
June
one-
1st, 2023 report you just asked
Counselor,
about.
okay, this counselor also referenced a different case as well. So what is, sorry.
So you were cross-examining that in your conclusion section, you indicated regarding the question of whether the individual had a mental illness defined by statute, Is it my opinion that he did not? I recognize my opinion on this matter requires clarification. So tell me about it.
Of this other individual?
Correct.
So again, that was a different case where I was again asked to offer an opinion on criminal responsibility. And in that case, again, there was some question about mental illness. In this particular case, if I recall correctly, the defendant had a history of mental illness, had been psychiatrically hospitalized. And so the question was, did the symptoms he previously experienced, was that impacting him at the time of the offense?
Now, doctor, is it the same thing to use your own work product as it is to take somebody else's and draw conclusions when the data doesn't support it?
No,
Okay, would you do that?
no.
And it's probably unethical to do so, wouldn't you agree?
If anything, it would be careless to do. If it was done on purpose, I suppose it could be.
Doctor, I'd like to refer you back to Dr. King's report, the page that Jeff Rhodes referred to, page 34.
Yes,
So the judge indicated that even on Dr. King's own validity scale, indicated that the defendant, at least in January of 2023, when these tests were conducted, he over-reported symptoms.
at least based on the scale, there was some indication of that, yes.
Okay. And you decided not to use these sorts of tests when you could have referred to a psychologist if you wished to. And you decided not to because why?
Well, for multiple reasons. One is that I didn't think he was malingering. I didn't have a specific question in my mind that he was feigning what he was telling me. He was forthright. And also because, again, my job for a criminal responsibility evaluation is to look at their mental state at the time of the offenses, and psychological testing is more contemporaneous. So
Meaning when the tests are conducted.
correct. So results that you get of a test in January of 2023 are not necessarily applicable to November of 2021.
So the next page, page 35, the last paragraph indicates that ideas of persecution, in parentheses, indicates someone who feels that he is devalued and trapped, and this trap is constantly persecuted with no means of escape. Now, wouldn't you expect someone to be in a jail cell for over a year to have some of those kind of feelings?
It's very possible, yes.
Are you aware of the recent changes in federal law regarding guidelines housing juveniles in an adult jail?
Yes,
So this defendant could be within neither sight nor sound of another adult prison. You know that?
yes,
So that would contribute potentially to some of those cases.
very potentially, yes.
And again, this test was taken a year after the shooting, a year or more.
Correct, over a year later.
Now, I just want to show you something. This has been admitted as exhibit 42. This is just a snippet of the in-car transport when right after the shooting, right when
But that's the other.
please, go ahead.
Yes, what I was saying is that his face isn't always in frame in that video, so you can't always tell, again, what he's looking at or doing, but he's certainly not moving around a lot. He's not speaking, there's no audio. The first audio, I believe, is when he asks to have his toilet paper taken out of his ears when he gets out of the car. But the next video of him in the police substation, he's shown for an extended period of time, talking with police, talking with his parents, and then sitting calmly as well, alone in the room.
I'm gonna go ahead and play a portion of that. That's exhibit 43. And the interview room up in County Jail, right? And this is again right after the capital adoption.
Yes, or it's not.
Noise we're hearing, is that the defendant making a noise?
Yeah.
Okay, you notice. You know, if it's like closing here.
No.
The police officer indicating the defendant in a few minutes to respond.
It's not relevant.
All right. Go ahead and take it up there, okay? Thank you.
You want it on the wall or? Yeah, it's fine. What pad you in? Right, okay. Shouldn't really pat it down. I'm gonna take the shoes off.
Again, the defendant respond appropriately to the question about.
Right, now repeat for me. Take both your shoes off.
The second here, the timestamp is November 30th, 2021, 14:35. So that's 2:35 in the afternoon. Is that right?
That's right.
The defendant committed these murders 12:51 p.m. So this is just a short time after the murder. Is that right?
Yes.
I'm not gonna play too much more. I just want to make sure. Verify looking inside.
Thank you. Raise your right foot out to me. Thank you.
The other one? Thanks. What's your name? Ethan. Ethan, what's your last name? Crumbley. What is it? Crumbley. Crumbley. Alright, keep back here for a second.
Okay, again, Doctor, now it's 14:36 on the timestamp. One of the investigators is asking some basic information from the defendant, and he responds to that.
He does.
Is it significant to you?
Yes, he's responding relevantly, he's paying attention, he's not speaking out of turn, his speech isn't disorganized. He goes on to answer more questions, and later his parents come in and he speaks with them as well.
Okay. Now, you mentioned toilet paper in the years. Did you come to learn in your interview of the defendant and a review of the evidence in this case that the defendant took steps to protect his hearing by stuffing toilet paper in his ears?
Yes,
Did you also learn the defendant went to the bathroom multiple times before the shooting occurred to load the firearm?
yes.
Okay. What does that signify, if anything?
It suggests the capacity for planning and also for delay. So again, when we think for a criminal responsibility evaluation of someone's ability to conform their conduct, the ability to delay things is significant, because if someone is so overwhelmed with mental illness or psychosis, they're usually impulsive. They may act very impulsively. But in this case, the defendant went multiple times into the bathroom at different points prior to the shooting to load the gun or get the bullets out. It was a multi-step process. And that suggests that he had the capacity for delay. He could have just done it all at once the first time. He just couldn't wait because he was so overcome with delusions or hallucinations. But that's not what happened. And instead, it was very planned, demonstrated his capacity for delay, and suggested the ability to conform his conduct.
So capacity for delay, is that another word for lack of impulsivity?
Yes,
Now, you were asked early on in cross-examination if you spoke with the prosecutor's office, specifically me. You recall that?
yes,
And in fact, you also spoke with Ms. Lawson too.
yes,
Okay, is it your goal to obtain as much information as possible?
absolutely.
Why?
Because the more data, the better in forensic evaluations. We don't want to just rely on one piece of data. We want the defendant's self-report. We want all of the available data that we can get, and we want to use our clinical judgment. That's how we come to conclusions.
Now, Doctor, you were asked about some things the defendant said to you during your forensic interview of the defendant. You recall that?
Yes,
Okay. And the defendant also said that, this is page 42 of your report. It said, when I got the gun, I was like, I have it, let's do it. And I was like, it's a crazy idea, but it just kept coming. He added that owning a 9mm made me feel like, oh my God, I'm awesome. He stated he'd like to show the gun to his father and say, I'm a bigger man because I have a bigger gun. He said that to you?
he did.
And then he also told you about how the day of the shooting, he set his alarm for 5 in the morning to wake up and to obtain the weapon. That's on page 44.
Correct. He told me that he would often sleep through his alarm, but on the morning of the shooting specifically woke up at that time because he knew his parents would be asleep so that he could obtain the weapon.
And at that point, he already had known where the gun was at, and the bullets were at.
Correct.
So I want to go back to something that Dr. King said regarding suicidal ideation. Now, let's be clear, that is not a sign of psychosis, correct?
Correct.
Okay, and can you please explain it to me?
Suicidal thoughts are not the same as psychosis. Psychosis is gross impairments in recognizing reality. Suicidal thoughts may seem illogical to people, but people can be suicidal for multiple reasons, and they're not considered the same thing medically.
As a mental health professional, why is it concerning to even hear somebody testify?
Well, it's not accurate.
There's also stigmatized mental illness and treatment for mental illness.
Yes, again, psychosis, suicidal thoughts, mental illness in general is heavily stigmatized in our country at times. And as mental health professionals, we're always trying to destigmatize mental illness and allow people to feel comfortable and get comfortable.
Dr. Crumbley, you were asked about the DSM and the symptoms of major depressive disorder. And you indicated that the defendant did exhibit some of those symptoms, but you still did not find a diagnosis of major depressive disorder with severe psychotic treatment. Is that right?
Correct.
Explain to me more.
So many of the disorders in the DSM have criteria that you have to meet, 5 or 7 or 4 of 8. But you also have to have a level of functional impairment along with the diagnosis to make it a true diagnosis. Because if someone is depressed, but they're going about their life as usual, they might not meet criteria for a major depressive disorder. So again, I think that the questions were about the major depressive disorder diagnosis, and I'm certainly not contesting that the defendant had the symptoms that were exhibited back at least in times of the spring and as time went on. But in my opinion, that level of functional impairment wasn't there to make that diagnosis.
And so again, you're not contesting that he exhibited signs of depression and that there was leakage in this case, correct?
Correct.
And then you take the text messages to a friend at face value that back at least the spring of 21, he was asking for help. Is that right?
Yeah.
Okay.
Yes.
But you could still, on November the 30th of 2021, appreciate the wrongfulness of misconduct and perform his actions should he chosen to do so.
That's my opinion, yes.
Thank you, Mr. Brother.
Thank you. With that, any reason why this witness should not be excused?
Not continued, but thank you.
Thank you, doctor. You may step down. You may also leave the courthouse.
For the people rest of the developed case, I just want to confirm the court has exhibits 1 through 64 admitted and 66, and 65 is introduced but not admitted.
Thank you. I have admitted 1 through 62. I have defendants A through W. I have people 63, 64 have been admitted. 65 was offered but not admitted, and 66 has been admitted.
Thank you, sir.
Thank you. With that, we're going to take about any further witnesses.
Now, from the people, thank you.
Thank you. People rest.
Yes, sir. Thank you.
With that, we'll take about a 10 to 15-minute break. When we return, I will hear closing arguments from both sides.
Thank you.
With that, deputies, you may take the defendant. Those in the courtroom, please be seated until the defendant has exited. Thank you. We'll take about 10 to 15 minutes. The court stands in recess.
All rise.
Thank you.
Your Honor, calling People versus Ethan Crumbley, case number 279506 FC.
Thank you. Here's the record.
Thank you, Mark. Please look at people.
Good afternoon, Your Honor, David Glenn, look at.
Oh, Michelle Lofton on behalf of. On behalf of Ethan Crumbley.
Thank you. With that, you may all be seated. People prepared for a closing argument?
Yeah.
Thank you. You may proceed.
Sorry, my name is Karen McDonald. I'm the elected prosecutor in Oakland County. And before I get started, I want to state that I've dedicated my entire adult life to helping and advocating for kids. I was a public school teacher, a prosecutor, a family law attorney, a family law judge, and I ran for this job on a platform of fair and just prosecution. Treat kids like kids, show compassion, try to help people avoid the criminal justice system. When I took office, I reversed the prior prosecutor's decision on juvenile life without parole sentences, 26 out of 30 individuals who were serving life without parole sentences for crimes they committed when they were juveniles. Based on those decisions, many were released. I did that because I believe in the sound reasoning and policy of Miller versus Alabama, which is a United States Supreme Court decision from 2012. I believe that a juvenile's youth and their characteristics should be weighed, considered before imposing the most harshest of sentence, except the death penalty. I believe it is a rare person who can be labeled irreparably corrupt, especially when that individual is a juvenile. I believe that the practice and pattern before Miller was that the criminal justice system made no distinction between a juvenile and an adult, and that needed to change. Before Miller, if a juvenile was charged for what is considered adult behavior, they were treated as an adult. I tell you all this because I believe it's my duty and my moral obligation to be transparent about why I stand here today. Because it's the last place I thought I would ever be. Standing here with a room full of parents and family members that had their children murdered, shot, and terrorized. Asking this court, or any court, to sentence a 17-year-old to life without parole for a crime he committed when he was 15, it was the last place I thought I would be. And it is the last place I want to be. In her opening, defense counsel stated, a court, quote, must undertake a searching inquiry into the particular juvenile, as well as the particular offense, and determine whether this is truly a rare juvenile for whom life without parole is constitutionally proportionate, end quote. Historically, Your Honor, advocates and jurists, prosecutors, defense attorneys on each side have framed their position around a juvenile life without parole sentence by leaving out essential components. Those who oppose a life without parole sentence for juveniles focus only on the mitigating circumstances of the offender, and only mention that, of course, the crimes were heinous. Likewise, proponents describe only the horrific acts of a crime, but for the most part, ignore the individual mitigating circumstances and the offender. You're not going to hear me do that, Your Honor. I'm the prosecutor. I'm taking this position, but I'm not going to ignore any of the facts, whether they help the defendant or help my position or they don't. And I haven't allowed any member of my team to do that since the day of that shooting. I have instructed, and they have done, to look at all the facts and the data and the research and the science, and most importantly, the truth, and consider all of it. And after having done that, I'm standing here today and I'm asking you to sentence him to a life without parole sentence. United States Supreme Court Justice Sotomayor, who authored the Miller opinion in 2012, stated during the oral argument on that case, quote, not every juvenile is equal. Not every murder is equal, end quote. So let's review what the testimony showed us about this particular juvenile and these particular murders. Ultimately, Your Honor, your task is to answer this question. Does the evidence surrounding this defendant and these offenses, when viewed in the face of any mitigating evidence that the Miller factors may offer, justify a life without parole sentence? And I believe, Your Honor, you will conclude that it does. I know the court is well aware of the law. We're dealing here with Miller versus Alabama, a United States Supreme Court decision from 2012, then Jones v. Mississippi from 2021, and then a Michigan Supreme Court case, People versus Taylor, in 2022. And what do those cases together ask us to do? What does it require the court to do? It requires the judge to fashion a proportionate sentence. And fashioning that sentence, the court can consider and should consider the core reasons and what makes a proportional sentence historically in this country, dating back to the 8th Amendment and the Constitution of the United States. And those are the following: deterrence, punishment, retribution, rehabilitation, and then protection of the public. In doing so, the court is required to consider the offense, the offender, the Miller factors, and anything else the court decides is relevant. It should be rare. It should be rare, Your Honor. And that's why we as prosecutors have a duty to use our discretion and follow the law. And that's what we've done here today. The first Miller factor asks the court to consider the juvenile and this crime in relation to the hallmark features of a juvenile or an adolescent brain, which involve immaturity, impetuosity, and failure to appreciate the risks and consequences. Your Honor, I argue that the evidence shows that his actions reflect the opposite of these hallmark features. There was extensive planning, and the court heard that. We heard that he put toilet paper in his ears to protect his hearing before the shooting. He researched and knew what kind of weapon he needed, and the one his parents already had for him was not going to do the job. So he advocated for a higher power firearm with more deadly bullets. He practiced. He went to the shooting range and he practiced. And if you have any question about that, look at the shooter's stance during that shooting, during that video of those awful minutes where he murdered 4 kids. He wrote about his plan over and over and over again. He searched up a map of the school on his phone. He searched that there would be no and new death penalty in Michigan. He knew which prisons a juvenile could be sent to. He knew that he would be sentenced to a life without parole. He knew the average response time of law enforcement that it takes to get to a school once a school shooting is reported. Your Honor, he also sat during those ALICE trainings. He was also in those classrooms where they taught people like Heidi how to install a nightlock device. He knew the damage the particular bullet of this weapon would cause on a human body. He bought and with his mother, when he was there at the shooting range, he bought and saved rounds from that day for this shooting. And even their expert, Dr. King, stated on cross-examination, he did not believe this was an impulsive act. The implementing, their expert, Dr. Daniel Keating, who I have a lot of respect for, and what he's contributed to this analysis and mitigation experts, describes this phenomenon of a runaway train, where adolescents and teenagers can get into a situation and they're not equipped to stop it, and they don't know what to do. That's not what happened here. There was an execution of this plan. There were opportunities to stop. There was the picking and choosing of who would die. There was a level of comfort with the ease with the violence and pain causing to young baby birds, to young children, and a level of excitement and joy. He learned firearm discipline. He surrendered before he ever even saw the police because he wanted to live. Over and over, he stated, and the defense expert stated, he wanted a chance to be caught. Your Honor, he sat in the counselor's office from 9:14 a.m. to 10:52 a.m. and never once said, I have a gun and I am going to go shoot up the school. Because no one else knew he had access to a gun other than the shooter, except his two parents. But in that room, he did not say it. He fired 32 shots, and every single shot was aiming at a human being. This was not a spray of gunfire in a hallway. It was intentionally aiming at human beings. The second Miller factor asked this court appropriately to weigh his family and home environment for which he cannot usually extricate himself. Your Honor, the people agree that James and Jennifer Crumbley neglected their son. The people agree that the text, that messages he sent when he was 10 and they couldn't be bothered to come home are heartbreaking. We agree that he was isolated, that when his only friend left, his mother made it worse by saying he would never be his friend again. We agree that they did not make him a priority. We agree that it has been shocking and devastating to have your parents say to the school counselor, we don't have time to take him for help. I agree with all of that, and I have compassion. I do, but both things can be true. We can feel compassion, but we can also fashion an appropriate sentence and reckon with the very severe, rare circumstances of this crime. We tragically have hundreds of kids every year who suffer severe physical abuse, sexual abuse, neglect. We have kids who can't count on meals or food when they get home from school, and some that don't even have a home. Except we have a very, very small number of adolescents who commit mass shootings. And this factor does not predominate over any of the other evidence surrounding this offense. The Miller factor 3 is the circumstances of the homicide and the juvenile's role, and whether there were other actors, whether he was in situations in the past where there's been an aider and abettor, or the person who drove the getaway car. Not in this situation, he was the only actor. Miller factor 4 asks the court to consider the incompetencies of youth, which affect the ability to maybe be charged with the lesser crime. There's no mitigation evidence as to that factor. And then lastly, the possibility of rehabilitation. I told you at the outset, nobody has a crystal ball. And we really haven't heard much about whether or not the defendant and the shooter can be rehabilitated in such a definitive way, because it would probably be improper and unethical to say that. And I do want to point out that this process of this Miller hearing as a prosecutor, given the case law, is imperfect. The people do not have an option of having an expert evaluate the shooter in the Miller case. We don't have the benefit or the right to demand an evaluation so that we can go hire an expert that we believe is credible to opine on whether there are mitigating factors and what that means. In fact, we asked for that for the defense, if we could have somebody interview and evaluate him for the purposes of whether to ask for a life without parole sentence, and they refused, which is their right, but they refused. I agree that juveniles have an increased capacity to change and grow, which indicates their actions are from transient immaturity. Here, though, there's a severe propensity and desire to commit violent and disturbing acts. And we see that by the fact that even after he was jailed in the Oakland County Jail, he used a tablet improperly and wrongfully accessed the settings on that tablet that he was provided and visited a reality gore website. I don't want to say the name because I don't want to give that website any more distinction. And when asked as to why he did that, he said he couldn't stop it. Taylor, the Michigan Supreme Court, does not require us as prosecutors to prove or the court to conclude that the defendant is irreparably corrupt. Instead, taken together by the United States Supreme Court decisions and Taylor, the court has to consider many things. The first is the offender. What does the evidence show? A propensity for violence, a fascination with weapons, a self-admitted desire to, quote, do bad. He consumed mass amounts of violent content online leading up to the school shooting, which include videos of people being shot, attacked with a machete, and stabbed, of a cat being boiled alive, a child being crushed by a van. He tortured and killed baby birds and recorded himself doing so, and then relished in how disturbing his acts were. Your Honor, I'm aware the courts viewed that video, and I respect the fact that you did not want it to be shown here, but we needed to describe it. And if you did see the video, which I know that you did, I did as well. And the most disturbing part about it, shockingly, isn't the mutilation and torture of these tiny, tiny little living things and drills going through their stomach and burning wings. The most disturbing part about it was the defendant's voice as he was doing it. He was literal. He exhibited pleasure from it. And it's something I will never forget. He discussed his desire to stalk, kidnap, rape, torture, and kill people on numerous occasions. For example, kidnapping, raping, torturing, killing, and dissecting another student. In a separate instance, he discussed drowning small children and how it would be, quote, the best feeling to look them in their eyes as they look back at you while they know that their entire life is about to end so young. And to, quote, stick your fingers into their eye sockets and push down so they scream in pain and drown their lungs with water, end quote. Defendant followed up by stating, whenever I see a little kid about a year old or a little more, I want to pick them up and run off of them, then torture them before throwing them off a cliff. He took pleasure in his appetite for violence, even acknowledging it was wrong by making comments such as, I love the darkness, it feels good. Knowing that you're different from society and not some mindless human like all the others. We have the ability to do stuff and that other people think is wrong, and we can tell ourselves that it's okay. He wrote, but I want to do bad. It satisfies me. He wrote, killing the innocent is the same as killing the bad. It both satisfies. And he wrote, scary thing is I like being this fucked up. I like it. I like being like this, end quote. Does a propensity for extreme violence and disturbing thoughts, actions mean he's necessarily mentally ill? As hard as that is for us to accept, we know from the testimony of a medically certified psychiatrist that it isn't. I have to talk about the offense now, and I know you've sat through a lot of really difficult testimony. The defendant shot 4 kids and wounded 7. At 12:51, he came out of the bathroom and shot Phoebe Arthur, who was a freshman and 14 years old. He shot her in the neck and the collarbone. He then shot Elijah Mueller in the face. He was 14 years old at the time. He was also a freshman. At 12:51 and 14, he shot Riley Franz, who was shot in the neck area. Riley was 17 years old at the time, and she was a student. Kylie Osage was shot next in the chest and the shoulder area. Kylie was 17 and a senior. He then shot Hannah St. Juliana, and we know that he killed her. She was shot multiple times in the left upper back, the abdomen, the thigh, and the forearm. She was 14 years old at that time, Your Honor. She was a freshman. And the thing that really, I do not believe we can forget is that after shooting her, he turned back and shot her again. Because it wasn't enough that she was already on the ground. At 12:51 and 16, he shot John Asciutto in the lower extremities. He was 17 years old at the time and a senior. We teach kids to run, hide, fight. And I will never forget the time I had to show Madison Baldwin's mother the video of how she actually died. Because Madison didn't run. Her instinct was to crouch down and curl up in a ball and put her hands over her head. He shot her at point blank range. She was 17 and she was a senior. 12:52, Tate Muir walks into the building and is shot in the back of the head. He was 16 at the time and he was a junior. At 12:52, 12, Ethan Watson was shot in the lower left leg in front of his shin. And he was a sophomore. Seconds later, he turned back and shot Tate for a second time in the lower extremity. At 12:52 and 54, he looked Molly Darnell, who was a teacher at Oxford High School, in the eyes, and he shot through the window and missed her heart by 7 meters. After that, at 12:58, in the bathroom, he motioned for Justin Schilling to come out of the stall, put him down on the ground, and shot him in the back of the head. He was 17 years old. He was a senior. In his last moments, he helped another student, Eden Gregory, who testified. You heard Keegan's testimony. You heard what it was like in that bathroom. You also heard him say that he said please as he was crouched on the toilet as Justin instructed him to do. And he ran as fast as he could, and it's the only reason he's alive. These students, they didn't attack the defendant, Your Honor. They didn't go after him. They didn't even try to really protect themselves. They surrendered. They did what he told them to do, and then he executed Justin Schilling. And he only stopped because there was no one left to shoot. You saw the video. Those kids were trained to go into lockdown, and they did. At the time the defendant went into the bathroom where he found Justin and Keegan, there were no more students to shoot, and there were no more classrooms left to be unlocked. Your Honor, I asked Keegan and I showed him, which was very difficult for him, the text messages that he sent to his family when he was in that stall. But I can't urge enough how we must not forget that the defendant is also charged and has been convicted of terrorism. Because there were hundreds of kids in that building who wrote and texted their parents very similar things. And parents everywhere who received those text messages from their kids saying, there's a shooter, I'm scared, I love you. And they weren't sure they would ever see their parents again. These kids were young, Your Honor. They were the innocents that the defendant wanted to kill. They didn't fight back. They didn't pose a threat. They were helpless, like the birds. And not only did this happen in a manner in which the motivation behind the acts, which is the very distinct thing I would like to leave with this court. These acts were carried out in cold and a calculated manner, no question. They were intended to have a devastating effect on as many people as he could, but they were also intended to derive pleasure and satisfaction from violence and nothing else. He stated he wanted to kill young people because they had their whole life ahead of them and they had a future. And he succeeded. He said, every night I lie awake, every passing minute I think about how many potential people will die. Think about it, all 10. People are living their lives right now thinking about how they will get a job and party at college and have a family and live a long life. However, what they don't know is that they only have a few months to live before they enter the dark void. Yes, exclamation point. He said the first victim has to be a pretty girl with a future so she can suffer just like me. He said he liked specifically killing the young birds because the birds, but I liked killing the baby birds more, mostly because they're so young and they had a wild life ahead of them, but then I took it away, always. That is what I like. And also they are helpless and they scream when you hurt them. He searched about response times in schools, different weapons, ammunition. As I stated, he knew that Michigan didn't have a death penalty, and he had a map of the school. This was an extended period of planning that was reflected in the journal. Passage after passage in the journal discusses his plan to shoot up the school including his goal, because the biggest school shooting have the biggest school shooting of this decade. His intent to kill the victims, to make the victims' families with sadness and distraught. And how he wanted all of America to see the darkness in him and hate him. He weighed the pros and cons of how he would conclude this horrific acts and debated whether he would kill himself or surrender to law enforcement. Defense counsel brought up Jill Peterson, who is the author of the Violence Project, and consulted with, and she testified in another proceeding. And I found that interesting because the one thing Jill Peterson will tell you that in her extensive, comprehensive, thorough database of mass shooters in this country, not one of them made a plan to stay alive so that you could see the suffering of the victims' families. He expressly contemplated these consequences through his journal and acknowledged that he would be spending the rest of his life in prison, and wrote the following: I'm about to shoot up the school and spend the rest of my life in prison. So yeah, I'm going to prison for life, and many people have about 1 day to live. I'm probably going to live the rest of my life in prison. I hope I can talk to someone though, so I don't take my anger out on other prisoners. Ever since I was little, I've wondered what it would be like in prison. Prison sounds harsh and no place to live, but it fits me and how I want to live. I'm going to spend the rest of my life in prison, riding away like a tornado. I wonder what life in prison will be like. I will continue shooting people until police breach the building. I will then surrender to them and plead guilty to life in prison. We'll never know if he heard the police or not. I don't know that. I'm not going to pretend that I do. What I do know is that they had breached the building, but they hadn't gotten to the defendant yet, and he surrendered. In one of the recordings, he states, I understand my consequences. I understand that people put me in prison for this. I've already said goodbye to everything. I went through all the phases. He acknowledged and he understood the wrongfulness of these actions and the consequences, which is at the core of why we needed in this country Miller versus Alabama. So we recognized the unique adolescent mind and its failure to really adequately understand the consequences. I don't know of a single other case where a juvenile has actually written extensively about the consequences of his future actions. He demonstrated this through a blast message he sent to his friend. I'm about to do something really bad and there's no turning back, so I will probably never be able to see you again. The exchange with Christy, the assistant principal, is both jarring but remarkable from an evidentiary standpoint and for the decision that you have to make. Because the defendant had already shot and killed students at that time, and he made a decision not to shoot her. And when you look at the defendant's demeanor throughout this whole proceeding, there was one time he was emotional, and it was when she was testifying. Because it was pretty clear this woman's dedicated her whole life to kids. She cared about the defendant. She'd known him for some time. She knew him when he was in elementary school. And she spoke about him with tenderness. But he didn't shoot her. And she didn't back down because she wanted to save him. He then went on to execute Justin Schilling after that and shoot Molly Darnell. Your Honor, the defense counsel also stated in her opening that she would offer not excuses, but explanations. I'm not even going to tell you the number of juvenile life without parole hearings and opinions and arguments I've listened to. But those cases, in almost all of them, there's nothing like this because there was an explanation. We might not like it, but there was an explanation. There was a theft. There was a robbery. There was a violent eruption between family members. There was a plot among peers, adolescent peers, and one thing led to another, and they all did this together, and there was pressure. There was substance abuse. There might be a drug deal. it was gang violence. There's a context and it did offer an explanation. No excuses. Where is the explanation? I did not hear it. I did not hear it. But I did hear how their expert believes he's mentally ill. And I want to talk about that. Because the central question of whether the defendant is mentally ill is applicable to the Miller factors. There's no doubt. But it is not the central question in this case because this is not an insanity defense. And in fact, the insanity defense was withdrawn in this case, which means there is no acknowledgement or even argument that he meets the statutory requirement for insanity. Yet, we sat and listened to Dr. King talk about all of the reasons why he thought he was mentally ill. And we like to think that there's got to be a terrible mental illness associated with somebody who derives pleasure from dark, violent things. I'm not gonna believe that. I do. But you know what else I believe in more? Science, data, research, doctors. And you cannot refute that. And that is what Dr. Anaker testified to today, which is that the majority of people who commit very violent acts in this country do not suffer from a mental illness. And more importantly, the majority of people who have mental illness are not prone to commit violent acts. And it's beyond proper. I don't have a word for what Dr. King described mental health issues in this country. He did them all. He did every single person and every kid in the United States who's ever had suicide ideations a disservice because he referred to them as psychotic. And beyond his testimony not being credible about the defendant, that is unconscionable. But the issue of mental illness you should consider. And if you decide that there's some mental health issues, I'm not going to persuade you not to, but it's to be considered in the light of the Miller factors. This is not an insanity defense hearing that was withdrawn. And I think this is an attempt to divert. And if it's an attempt to get compassion, he has it. He's got my compassion. I can do both things. You can do both things. We all have to do both things. We have to deal with the darkness and the violence, and we have to accept that it happened. And we can also say, we wish he had had a better upbringing. But we're not going to ignore facts. And the facts are that he had a choice. He had many opportunities. He plotted, he planned, he showed none of the mitigating factors and evidence that you see in hundreds of other juvenile life without parole cases. And I'm going to ask the court once again to rely on the testimony and the truth. The issue of what the school should have done or what somebody else should have done is not relevant, and it's not a mitigating factor. And blaming somebody else for not stopping a school shooter is for a different proceeding. But it is absolutely not inconsistent with saying that he made choices evaluating him, the offender, and the offense. He is guilty. He pled guilty, and he should serve the rest of his life in prison. Your Honor, this process is imperfect. We don't have the ability to get our own expert. We bear the burden, but we only have to rely on what the defense submits as their experts. And there are a lot of problems with one of those experts. That expert, Dr. King, came to this courtroom. He didn't know how many minutes the shooting took place. Didn't know how Justin Schilling died. And when I told you before, when I started, I'm not going to ignore the facts that don't support my position. We all have a duty to look at it all and to take the stand and only evaluate and report facts and circumstances that support an opinion, and ignore what happened in the school is not the law. And it's also not the right thing to do. A proportional sentence also includes what's right and proportional with regard to retribution. And that means we cannot evolve in a way that we will only apply our sense of decency without hearing what the victims went through. That is at the core constitutionally of what we should consider when we sentence anyone. And so we are obligated to tell their story and to tell what it was like, because that is constitutionally why and how the court fashions a proportional sentence. Your Honor, it's morally complicated to doom someone to life at the age of 17. I know, and I'm not going to stand here and say that it's not. But I told you at the beginning that I was going to rely and demanded that this team rely and consider all the facts and all of the factors that the case law says we should, and all of the mitigating factors and all of it, put it on the table. And while it's morally and legally complicated to do so, after having done that, I stand here today and I ask you to sentence the shooter to life without parole.
Thank you. Defense.
Good morning again, Your Honor. Everyone needs a safe place in their life. I don't feel safe anywhere. I'm gonna ask my parents to go to the doctors tomorrow or Tuesday again. This time I will tell them about the voices. I only told them about the people I saw. Like I'm mentally and physically dying. Over the weekend, I actually felt warm for once. I woke up from a good dream. I said to myself, why can't everything freeze right here? I had just hoped everything could have ended there and not a second longer. I feel like I'm in a time loop of sadness. I will forever not feel the love of another human being, and not even I can love myself, as I hate myself, probably more than some people already do. I barely made it through 9th grade mentally, as my depression was rough. Then I made it to 10th grade, and I have fully lost control. How the hell am I supposed to make it 2 more years when I'm already at my breaking point? Those are Ethan's words. Ethan was at his breaking point, and no one stepped in. Ethan had quit the bowling team. He had quit his job. He was failing almost every single subject. He sat alone at lunch. His only and trusted friend left. His dog died. He was hallucinating. He was hearing voices. He was depressed. He was suicidal. He was anxious. He was writing on a paper in the middle of class, surrounded by his peers. The thoughts won't stop. Help me. The world is dead. My life is useless. The prosecutor was right. He didn't come out and tell the counselor his plan. But did he have to? Wasn't it glaringly obvious? This was the 3rd instance in 24 hours. He was looking at bullets. He was watching a video of a shooting and now writing in actual words that he's hallucinating and needs help. And again, Ethan was overlooked. Ethan, in his own way, crying out for help, still went unnoticed. If there was a question about who cared about him, it was settled in the counselor's office. He sat there. His parents didn't greet him or touch him or act at all concerned and said, actually, we have to go to work. We can't do this right now. There was no question at that point that no one cared about him. Those are not my words. Those are the words of the prosecutor at the preliminary exam of James and Jennifer Crumbley. As a human, you want to try to rationalize things that happen, especially bad things, things against the norm, things that are unfathomable. You can't do that here. Because the thoughts put on paper in the journal, the words found in the text messages and the video, they are not rational. They are the ramblings and thoughts of someone gravely mentally ill. So as hard as we try to rationalize it, we are not able to. I want to talk about the Violence Project. You have that in your binder as Exhibit B. Ms. McDonald touched on that as well. It's a report that was prepared at the request of the prosecutor's office in the parents' case. Dr. Jillian Peterson testified in a Daubert hearing after examining much of the same evidence that you've been presented with here today. In that report, she states that the road to violence is a long, slow build over time, with the perpetrators providing numerous warning signs to people around them. The intervention needed to stop a mass shooting is often simple: a human connection, providing hope, seeing someone else's pain. She says that there is a common misconception by the public that mass shooters are evil monsters who just simply snap and commit a shooting. She goes on to explain the steps on the pathway to violence. She says in step 1, child abuse, exposure to violence, chaotic and unstable home, mental health concerns. Step 2, identifiable crisis point in the days, weeks, or months before their violence. Shooters communicate their crisis to others in noticeable ways: changes in appearance or behavior, or leakage of their plan to others. A final blow can be a major loss: failing a class, rejection from peers, paranoia that becomes unbearable. Step 3, shooters are almost always angry and lonely, and many fixate on a group that they can blame for their circumstances. It is common to blame school, peers, and motivated by a desire to make sure that they're going to make headlines so that they're known forever. Step 4, shooters have access to firearms and to the people that represent their grievances. She found that what is unique in this case is the role that the parents played in enabling him along the pathway to violence and ignoring his requests for help. Again, this doesn't rationalize his behavior, but it gives it context. So when the prosecutor stands up here to argue that the crime itself was so horrible that a life without parole sentence is proportionate, I argue that the very report that they had created argues against that. The people's witnesses that they called were only fact witnesses. They provided no expert opinion in their case in chief that Ethan is irreparably corrupt, no expert opinion that he cannot be rehabilitated, no expert opinion to say that his brain was fully developed, no testimony to show that his childhood was ideal. Nothing about what the witnesses testified to goes to the analysis that is required with the Miller factors. If we were here just to discuss the horrible facts of that day, we would be here for a trial. Ethan pled guilty. The court can see through the exhibits that are contained in the binder and the testimony that was presented exactly what type of family and home environment that Ethan had. This was a home with constant fighting, yelling, accusations of affairs, money troubles. This was a home filled with alcohol. Ethan was left home alone beginning from a very early age. We heard from multiple neighbors, and you can see it in a text with his mother when he's only 10 years old, begging his mom to come. He was left to cope with his fears himself, so he turned to violent video games, violent movies, and violent websites. In looking at the third factor, a fact that familial pressures may have had, Ethan repeatedly talks about the lack of money. The fact that he is a burden to his parents, his father's employment status, the fact that they can't afford college. We even saw in the text messages, mom wasn't even willing to pay any longer for braces. Ethan asked his parents for psychiatric help and didn't get it. He told his mother about the ghosts and the demons, the voices. The issue of Ethan's mental illness is shown in the conversations as early as 2020. And you can see those between the conversations between James and Jonathan. They're also shown in the conversations between Ethan and his juvenile friend, in the writings of his journal. What he Googled after receiving no help from his parents, he was trying to diagnose himself. Ethan did not have the support that he needed. It was glaringly obvious that he was not okay. His parents took a disturbed, mentally challenged, and possibly ill kid, their son, and what did they do? They didn't take him to a doctor. They didn't take him home. They didn't walk into that room and say, I love you. I'll do anything for you. What's wrong? They didn't embrace him. You know what they did? They bought him a weapon. Again, not my words, the words of the prosecutor in the case of the parents. I think that Ethan's parents' reaction to hearing of a school shooting says it all. As hundreds of parents drove way above the speed limit to make sure that their child was still alive, we found out what his parents did. His dad went directly home to look for a gun, and his mom texted him, "Don't do it." They knew he was in a crisis. All of the evidence presented as to his home life should be considered, and we argue clearly shows that the second factor, family and home environment, should be a mitigating factor. When it was our turn to call witnesses, we first called Dr. Romanowski. He was the expert in corrections, who didn't review the facts of the case, as that's not his expertise. His testimony goes to the heart of the fifth Miller factor, possibility of rehabilitation. Not whether he has already been rehabilitated, or if it is with 100% certainty that he can be, whether it is possible. He examined all of the records from the Oakland County Jail. The purpose of his testimony was a look forward after the day of arrest, not back. He has extensive knowledge of what happens after someone is placed in jail and when they're transferred to the Michigan Department of Corrections. He testified that Ethan had no major misconducts and has only a few minor misconducts. He explained the process that Ethan will go through. He'll be sent to the Thumb Correctional Facility with other juveniles, where he will obtain his GED and other certificates. He explained that once he is 18, he will either move to Haida Prison or move to the Michigan Department of Corrections with adults. He went through all of the programs and activities that Ethan will be able to participate in. The most important thing that Dr. Romanowski explained to us is what happens when a person gets a term of years. If your honor finds that the people have not met their burden and you hand down a sentence of a term of years, Ethan does not just walk out of those doors once he has served the minimum. Ethan has to prove himself. Ethan has to complete all of the available classes. He must attend therapy. He must not engage in assaultive behavior. He cannot receive tickets. He must show the parole board that he has changed, that he has been rehabilitated. If Ethan decides to spend the decades of his sentence assaulting inmates, racking up tickets, refusing to take advantage of the classes, he will not get out. He will continue to get flopped by the parole board and he will serve his maximum. This is a unique situation because this court doesn't have 15 or 30 years of records to look at. We can't show you on paper, look, judge, he has been rehabilitated, because he hasn't been to the Department of Corrections yet. I'm asking that you not penalize him for that fact that the law changed and we're doing this Miller hearing prior to the sentence. We ask that you give Ethan the chance to show this court and to show this community that he will do good things with his time. That when he stands before the parole board, there will only be positives to discuss. Denying the motion and giving him a term of years is not an automatic outdate. It is putting the ball in his court, and it is letting someone else make the decision when they have those decades of records. Everyone can be rehabilitated, as Dr. Romanowski said, if they truly want it and they truly work at it. We believe that factor, Miller factor 5, the possibility of rehabilitation, should be a mitigating factor because of the evidence that we presented. We then heard from Dr. Kadir. She has seen Ethan consistently in the beginning from the jail each day and then moved to each week. She has diagnosed him with major depressive disorder, recurrent episodes severe, and adjustment disorders with anxiety. These diagnoses are consistent with symptoms such as being hopeless, suicidal, having anxiety, hearing voices, seeing shadows, being unable to sleep, having nightmares, racing thoughts. All of these things Ethan reported, and we can see through the text messages, the video, and the journal. We know that he attends and actively participates in his sessions. He talks through situations, he's taught coping skills, breathing techniques. Ethan is currently prescribed 3 medications for his mental health issues, and he has been taking them voluntarily and consistently since October. She explained what a PHQ-9 score is, told this court that originally Ethan scored in the moderately severe range and now mild. That shows improvement. She does not know the facts of this case. Her diagnosis is based off his ongoing symptoms and what she observed from the moment that he entered the jail. Her testimony goes to the 5th Miller factor, rehabilitation, because he is making progress. He is taking the necessary steps to treat his mental illness. If the prosecutor wants to argue that Ethan is not mentally ill, but simply carrying out this master plan because he is an evil person, Does it make sense that when he would get to the jail, he would be depressed, suicidal, and anxious? No, he would be proud. He would be excited that he carried out his plan. And that's not what we see here. We heard from Dr. Keating, an expert in adolescent brain development. His research and studies are extremely complex, but he boiled them down for us. He explained how the adolescent brain is different than an adult. He addressed the first factor in Miller, describing impulsiveness, immaturity, impetuosity, and the failure to appreciate risks and consequences. He explained hot cognition and what happens when an adolescent's thinking is highly influenced by their emotional state. He explained that an adolescent may not be able to get off a runaway train even after realizing it's headed for disaster. And I know Ms. McDonald addressed this. In my redirect of Dr. Keating, I asked, does the train ride have to be a short one, or can someone get off and get back on and get back on and get back off and still be on a runaway train with the ability, not having the ability to get off of it? He agreed with me. Yes. So I agree. It may have been a long train ride, but it was clear it was headed for disaster and Ethan was unable to get off. Planning, research, and premeditation does not change the research findings that he presented. He says that there are no scientific studies or empirical data that can conclude that an adolescent is irreparably corrupt. I ask you to focus on section 7 of his paper, resilience. Two major processes have been found to promote resilience: social connection and mindfulness. The connections don't need to be within the immediate family. They can be teachers, mentors, doctors. Also, the normative brain changes of adolescents include a proliferation of new neural material and the rewriting of some critical neural circuitry. Ethan's sick brain can be repaired. That goes directly to factor 1 and to factor 5. We believe both of those factors should be mitigated. Finally, we heard from Dr. Colin King. He has spent 22 hours with Ethan. He has performed a litany of tests to confirm that Ethan currently has mental illness, that Ethan suffered from debilitating mental illness leading up to and on November 30th. His brain was on fire. That the journal, the text, the searches, the bird videos, the ramblings, they're all indicative of mental illness. That with proper intervention from school staff, counselors, and parents, this could have been stopped. That with continued therapy, medication, and a controlled environment with positive relationships, he can be rehabilitated. The prosecutor spent over 4 hours picking apart the report of Dr. King. The sentence form, the choice of words, what he didn't include, accused him of copying someone else's report, questioning his authority. But what they didn't spend a lot of time on is actually attacking his method of testing, the testing results, the graphs, and his actual findings. In their case in chief, they called no expert to refute the findings of Dr. King. No one came in here and told you he performed these 20+ tests incorrectly, and here's why. They didn't like what Dr. King was saying, so instead of finding an expert to agree with them and their point of view and come in to disprove his analysis, they attacked how he wrote the report. Now, Ms. McDonald said that they do not have the ability to have someone interview Ethan. I agree with that they can definitely call an expert to review Dr. King's report and create a report based on what they believe or what was wrong with Dr. King's report, and that wasn't done. Finally, the people called Dr. Anaker as a rebuttal witness. She was brought in when we filed a notice of insanity defense, and Ethan was referred for criminal responsibility. She examined him one time in March of last year. Her role was to evaluate him to determine if he was criminally responsible or if his mental illness rose to such a level that he was not criminally responsible. She wasn't his treating physician. She did not do any psychological testing herself, didn't have anyone else do it. We withdrew the insanity defense, and Ethan pled guilty. I do not agree with her opinion that Ethan was not mentally ill, and I don't think that the evidence that you've been presented with support that opinion. Nothing about her testimony or evaluation was about how he will be in the future. Nothing of what she testified to addresses any of the Miller factors. Now, one thing I found interesting about her report was when she discussed that she believed that the voice in Ethan's head was his conscience. I think that should go towards the first factor as further reason it should be mitigated. One doesn't have a conscience if they are this cold-blooded person that the prosecutor describes. For the prosecutor to stand before you today and argue that Ethan was not mentally ill is disingenuous. We do not operate in a vacuum. James and Jennifer Crumbley are charged on a different information and their case is in front of a different judge. But the people cannot stand in this court and say Ethan does not have mental illness and then stand before Judge Matthews, the Court of Appeals, and now the Supreme Court and argue that he has mental illness and that he was mentally disturbed. Their court filings are full of statements and arguments that support their belief in that case that he has mental illness. I want to go over a few of those. Preliminary examination held in front of the Honorable Julie Nicholson, February 24th of 2022. These are the words of the prosecutor. Both Jennifer and James Crumbley knew that the evidence showed that their son was experiencing disturbing mental health issues in the months leading up to the shooting. Found in their brief in support of the people's motion in limine to admit evidence, their son was manifesting signs of mental distress, expressing those manifestations to the defendants and asking them for help. Filings in the Michigan Supreme Court. Those devices and social media search warrant returns produced evidence showing that defendant's son was displaying signs of being in crisis, reporting hallucinations, and asking for help. We have one set of facts here. You can't stand in two different courtrooms and argue two different things when it's one set of facts. I want to close by discussing the law that the court must follow when making this decision. The prosecutors have continuously argued that because this crime was premeditated through writings in his journal, internet searches, and his recorded video, that life without parole is automatically proportionate. That the crime was so heinous that their burden is met. I don't agree, and I don't believe the law agrees. All cases where a juvenile is facing life without parole are premeditated homicides, the worst of the worst cases. The courts in both People versus Skinner and People versus Bennett held that the fact that a vile offense occurred is not enough by itself to warrant the imposition of a life without parole sentence. They presented nothing else but facts. The law requires that we start with the presumption that life without parole is a disproportionate sentence. The people bear the burden to rebut that presumption by clear and convincing evidence. They must prove that Ethan Crumbley is one of the rare, irreparably corrupt youths that cannot be rehabilitated. The court must look at the Miller factors to make that determination. In an unpublished opinion from just a few weeks ago, and I do have a copy for the court, People versus Paredes, the Michigan Court of Appeals upheld the finding in Taylor that Miller factors are mitigating and cannot be considered aggravating. Meaning, if a particular Miller factor does not mitigate against life without parole, at most, the factor has to be considered neutral. Our witnesses have touched on all of these factors, and we believe them all to be mitigating. Both sides spent an appreciable amount of time talking about mental illness, which in plain language is not stated in the Miller factors. The people asked Dr. King where he thought mental illness fits into the Miller factors. Well, People versus Bennett touches on that issue exactly. In that case, the defendant was also a youth who had a turbulent family history and untreated mental illness until he was incarcerated. The court held that treated mental illness is not a signal of irreparable corruption. Mental illness is universally recognized as a mitigating factor. The court held that the Eighth Amendment requires judges to view mental illness as a fact that mitigates an offender's culpability for committing a crime. Everything that has been presented here, whether it be in my exhibit binder or from the witnesses who came to testify, show that Ethan Crumbley suffered from untreated mental illness. The testimony of Ms. Gibson Marshall, the assistant principal, was very important. She said as she walked toward the student with a gun, she realized it was Ethan. She said, "No way. It can't be Ethan. Ethan wouldn't do this." Your Honor, the same Ethan that Ms. Gibson Marshall knew is the same Ethan I've gotten to know. The person that you see in that video is not the person who sits beside me in this courtroom. The reason he didn't shoot Ms. Gibson Marshall, she called his name. She acted like she cared. He finally had someone who was caring about him. Lieutenant Willis in his testimony said that it was nearly impossible when he arrived at the school to set aside his emotions and do his job. The statements couldn't be more true. Same is true for Ethan's defense team, but we're here to do our job. And Your Honor, as you go in back and review everything that you have been presented with, we are asking that you set aside the emotions and you follow the law. We are asking that you deny the people's motion and sentence Ethan Crumbley to a term of years. Thank you.
Thank you. People rebuttal.
There are a few things that we have in our integrity is one of them. For counsel to stand up here and call me unprofessional or inconsistent and making arguments that suit me in different cases is offensive, it's unconscionable, and I will only respond by saying, please do use our language, our drafting, our pleading, and our argument on every single thing that we've ever said on this case or the parents' case, because the language is intentional and it's knowingly made. And it's known with the knowledge of what mental illness is and the definition of it versus, and I'll quote who was quoting me, the counsel, mental health issues, crisis, mental distress, and crisis. I'm not sure what would convince counsel or anyone besides the testimony of a doctor, because I can bring 100 more to say the same thing. That is not the same thing as saying somebody has a mental illness that meets the statutory definition, which is what I am arguing, because that's the science, that's the data, and counsel knows it very well, which is why there's no insanity thing. So to stand here and say that I'm saying, and my team has said something inconsistent is, first of all, ignorant and unprofessional. It is absolutely not true. And if the court needs more information, which would surprise me, but if the court needs more information between what mental illness means and the distinction between mental illness versus mental health issues, someone being in crisis, someone being in mental distress, someone being in crisis, by the way, could apply to all of us at one point in time in our lives. No one's going to argue that. That is what that's called. But the evidence and the data and the science do not show that he meets the statutory definition of mental illness. And that is what Dr. Annenberg has testified to, because it's the truth. And this is not a legal insanity hearing. That plea was withdrawn. That defense was withdrawn. So I agree. Mental distress, absolutely. Crisis, absolutely. Disturbing behavior, requests for help. Yes, I agree. We really don't disagree on very much, except I'm not lodging a false accusation and then trying to misstate the truth. I have not ever stated that he had a quote mental illness or that he did not. I don't know. I know and believe in the science, and I think counsel does too. That is why there was no insanity defense, because it doesn't meet the statutory definition of that. And I agree, all of this is mitigating. We really disagree on very little. What I am gonna though do is what I said I would do in the outset. I don't want to ignore any of that. You shouldn't ignore any of it. However, your job pursuant to the case law is to fashion an appropriate proportional sentence. And that, per the case law, is described as taking into consideration the Miller factors, every single one of them, and the offense and the offender. I, again, don't want to get too off track here, but the proper course to litigate when you're in trial is you put on rebuttal witness based on the testimony of expert and the defense case in chief. That's proper. That's what you're supposed to do. And that's what we did. We don't have the ability to call an expert and talk about rehabilitation. And it would not be proper because we don't have the ability for that expert to actually evaluate the defendant as to that. So we did what is proper in these hearings, which is to respond to the testimony presented by the defense case in chief and what we felt needed to be cleared up because some of it was just not credible. So let's talk about that. They called 4 experts, and I agree with nearly every word 3 of them said. I know that the juvenile brain is different, and I acknowledge it. I know that people who commit terrible crimes at 15 change over time, their brains do. And so why are we here, knowing all of that? Why did we make the decision? Why did I make the decision to seek a life without parole sentence? I struggled with that for a long time. To be clear, I did not make a final decision about that position in the 21 days that the law allows us, where we have to give notice after a guilty plea. We did file notice and waited for a defense mitigation expert because we don't have a right to get our own. Waited for a defense mitigation expert to tell us something about this crime we might not know, to tell us something about this defendant we might not know. And I didn't just wait for it. We actually tried to make it happen because the first report that was given to me lacked serious mitigating factors that you should consider for the defendant. Didn't even include it. Did not have anything about the argument with his parents the night before. Did not have anything about what that thought process was and what was happening. Your Honor, there's a lot of people who would stand here and would never do that. And I have a problem with it, which is why I'm the prosecutor, but I believe in fairness and justice. And I believe that we should take very seriously a juvenile if we're asking for a life without parole sentence. And that the court must consider in circumstances like that. And it wasn't in their expert's report, and it was lacking. And there were also items in the report that weren't even true. So as an officer of the court, and also just being a person who morally feels that we have standards to live up to, I asked for him to include it, and he did. What did we get with Dr. B? We had a partly plagiarized report from someone who did not know the Miller factors. He focused on the wrong things. We learned that eggs break when you drop them and implicit bias is real, but neither of those things have anything to do with your decision. I would note that there's not a single shred of evidence that this defendant suffered a brain injury, yet Dr. King basically his opinion is he probably has one. He didn't know how many minutes the shooting lasted. He didn't know how those kids died. And it didn't even seem like he cared. Dr. Anneker testified the objective known facts suggest the opposite of a brain injury. And in my effort to gather all that information, I also asked the defense to allow a prosecution expert to interview the defendant. And they refused, which is their right. So I was left with 3 things. I had Dr. King's report, which I do not believe is credible. I had Dr. Anneker's report, which thankfully was extremely thorough and balanced. I did rely on that and stand by her conclusion that he does not have a mental illness pursuant to the statutory requirement. And that's all I can say. And that's all she can say. But that doesn't mean he wasn't indeed experiencing a crisis. How can anyone say he wasn't in crisis? How can anyone say that he wasn't in mental distress? I agree. Consider it. It's mitigating. You should consider it. But you also have to fashion a proportional sentence. I sought out people and experts I knew might disagree with me. I asked people to disagree with me. I trusted them to tell me the truth, where that might lead. And in doing that, I learned that there has never been an offense or offender like this one, not just in our state, but our country. This is a person who killed 4 of his classmates solely for the pleasure of killing and to increase the body count to try to make himself famous. It wasn't impulsive, and their expert even acknowledges that. He didn't want anything from his victims, Your Honor. It wasn't settling the score. He didn't even know them. And the people he killed were also juveniles. Tate, Hannah, Madison, Justin. They had their whole lives in front of them. And in fact, that's his motivation. He wanted to kill people who had their whole life in front of them. And this is a person who, unlike any other, researched and planned how to survive the shooting to see his victims suffer. For this defendant who committed these offenses, and the way he thought it out and did it, life without parole is not a cruel or unusual punishment, which is what the 8th Amendment stands for. It's a just, proportional sentence. His life will be spared. His life will be spared just the way he wants it. He can continue to watch his victims suffer if he can do it from a place where the victims will never have to live in fear that they will face him again, or that he will do it again to someone else. And even if the defendant changes and he finds some peace and some meaning in his life beyond torture and killing, does not mean that he ever gets the right to live free and among us. And that's not what Miller says either. Miller says you have to consider everything, and I want you to do that. And when you do that, this defendant should be sentenced to life without parole. This is a right and just proportionate sentence. And lastly, there's another important point about the Miller decision. It avoided an absolute, Your Honor. It didn't say always or never. I listened to the oral argument in Miller many times, and that's what counsel for the defense was arguing for, an absolute line. The Supreme Court didn't do that. And I have found a lot of wisdom in that idea, both pursuant to this hearing and in all of the decisions I've made in my life, of avoiding absolutes. Because when you say always or never, a case will eventually come along that you didn't consider. And it did for me. You haven't heard me stand up here and call him a monster. I don't describe him in some inhumane way. I want and do allow the law to guide me. But I'm not going to shy away from these horrific facts and the evidence. And I know you won't either. Rarely, something very rarely, an exception comes along. And it did. And he's sitting a few feet from me. Please give him a life without parole sentence.
Thank you. With that, as counsel is aware, I am going to, before I get there, I want to make sure that I have all of the exhibits before the people in defense leave. I do have the binders, but please make sure the court has any recordings that you all admitted into evidence as well. Please leave that with my clerk before you leave this afternoon. With that, as the people as well as defense are aware, the court has to make a decision of whether or not the people have met their burden by clear and convincing evidence in conjunction with the Miller factors. And so, as I stated before, off record, I'm going to give you all a decision date, and that decision date will be set in the next 35 to 45 days. I note that we must have a placement hearing for the defendant every 30 days, but because of the vast amount of information that the court has been presented, I've been presented for nearly 4 days of testimony. I've been presented with 2 full binders, and the court has to go through all of the evidence before I make a decision. I also need to do additional research on the law before I make a decision. And so I will note that it's going to take some time to make a decision, but I plan on giving you all a decision in the next 35 to 45 days. Because of that, I'm asking the counsel if you all have any objection to waiving the 30-day provision under the Juvenile Justice and Delinquency Prevention Act and setting this matter out past the 30 days. Any objection from defense?
None at all.
Any objection from the people?
No, Judge, thank you. I did want to ask if the party did wish to supplement the record of bench brief. When the court met.
Thank you. I will note that I intend on trying to get a decision as soon as possible. I have received your briefs prior to the hearing. Quite frankly, I don't believe I need any more briefing from counsel at this time. So respectfully, I'm going to ask that you not submit any supplementaries. I believe that I've been presented with enough information over the last 4 days, and so I don't need supplemental briefing. And so what I'm going to do is set this matter for a review hearing as it relates to the defendant's placement, as well as a decision date. The decision date / review hearing will be set for
September 29th, 2023 at 9 a.m. via Zoom.
going to do. And again, it's going to be via Zoom. I will note at this hearing on September 29th at 9 a.m. via Zoom, there's going to be no need for any additional argument. It's simply a decision date. And so I know council is aware, but so members of the public are aware. The court will not hear from any victims on that date because, again, the court's sole purpose on that date is to determine whether or not the people have met their burden by clearing convincing evidence. And so I will not hear from victims on that date. However, I will hear from victims on the actual sentencing date, as I must do pursuant to the Crime Victims' Right Act. And I did have an opportunity to meet with the Michigan Department of Corrections as I advised counsel off the record. Again, I know counsel is aware. For count one, there's several victims. There's my understanding more than 2,000 victims as it relates to count one alone, that being the terrorism count. And under our statute, the Michigan Department of Corrections has to attempt to reach out to those individuals. I did meet with one of the leaders of the Michigan Department of Corrections, I believe either a week ago or a week and a half ago, and they did assure me that they would have the precinct's investigation report completed by at the very latest, the end of November. And so I asked them to make sure to get me that report ASAP, to also provide it to the people in defense ASAP, and so we can deal with any issues beforehand. And so what I'm going to do, set this matter for a sentencing date. The sentencing date will be in person. The sentencing date will be set for
December 8th, 2023 at 9 a.m.
With that, again, the reason that the court is setting the sentencing date out that far is to allow the Michigan Department of Corrections to prepare the precinct's investigation report. Again, as counsel is aware, there's a statute here in Michigan. I cannot sentence a defendant until I have that pre-sentence investigation report. I must have that report before I can do anything further in this case as it relates to sentencing that defendant. And again, I've been assured that by December, they should, by late November, early December, they should have that report completed. And they did request that amount of time. And so, again, the court understands that this matter has been pending for quite some time. I understand that, but because of the law, I must have that report. I cannot sentence them without it. With that, please provide the exhibits to my staff. Is there anything else we need to address for the record this afternoon?
No, thank you.
Thank you. With that, deputies, you may take the defendant to those in the courtroom. Please be seated until the defendant has exited the courtroom. Thank you. With that, everyone, have a great day. I will see you all in a few minutes. Court stands in recess.
All rise.
Recording stopped.